Esther De La Fuente.
Hello.
Hi, thank you for dressing appropriately for court. All right, today is the plea deadline date. Is this going to be a jury trial?
Judge, I got retained a week ago on the case. I
Mhm.
got discovery last week on Wednesday. I got an additional 8 or so body worn cameras. I'm still working on my way and going through. We just requested a reset until I have time to review the discovery.
All right, so her plea deadline date was extended from August 28th to now, and then it was extended again. So what I'll do is we can recall this for tomorrow, and tomorrow is the last plea deadline date. The court will not extend it any further. Do you understand?
Yes.
All right, Ms. Ferguson, recall this for tomorrow.
Yes, ma'am.
All right, thank you.
Thank
Thank you, Judge.
All right, once you sign the reset form, you're excused. All right, Mr. Aceves. Hello, good morning. How's everything going?
Yeah, pretty good, pretty well. Still working on my same place and living with my family.
Oh, that is awesome. How's he doing?
Doing good, Judge. No concerns at all. Reports on time. Every UA has been negative. He's just been working and doing what he has to do. There's no concerns at this point.
Okay. And so, and how long has he been on probation?
So we were just discussing that he's been on probation 2 years.
Okay,
He asked about, possible early termination. I told him he would have to get with his attorney on that
yes.
based on the offense type, kind of went through the time frame. So
Okay. All right, I'll tell you what I'm gonna do. This is what I will do. I will reschedule you for another update, and if things are still going well, maybe he can report by mail. Is that possible or no?
I would have to check on that, Judge.
All right. So you want to bring him back in the new year?
Yes.
All right, Norma, I need a date in February. And it's just for status. February 23rd. All right, we'll see you back on February 23rd, okay? All right, thank you. All right, Rafael Sanchez. All right, so
Right now, on record.
today's plea deadline date.
That's correct, Judge.
All right, so jury trial, or is he accepting, or have you all reached an agreement?
No, Your Honor, we would like a jury trial.
All right, how long do you expect the trial to last?
I would say 3-ish days.
I'd agree, Judge.
All right. You can either do a jury trial or a bench trial. With a bench trial, the state will have to agree. With the bench trial, evidence is presented to me and I make a decision. Do you understand?
Yes, ma'am.
So do you want a jury trial or a bench trial?
Yeah.
All right, Ms. Ferguson, I need a jury trial date, 3 days. All right, January 6th. All right, once you sign the reset form, you're excused, and you all need to make sure that I have an acknowledgement of discovery.
Yes, Your Honor, I'll make sure of that.
All right, thank you. Just have a seat and he'll bring the reset form to you. Thank you for dressing appropriately for court. All right, thank you. All right, Fidencio Gonzalez. Hello. Good morning. So what are we doing with this case?
Judge, there's a motion to set bond before the court, and then I believe we're set for status. We had been going back and forth with discovery, but the state will be providing discovery to finish. What happened, Judge, is I had provided a solid state disk drive that didn't work when I received it back, and so they're making another copy for me. They've tendered a pre-offer today, Judge, so we're just asking for the court to set a bond on this case and to reset it with a status conference. I'll show you.
All right, could I have the bond motion? Thank you.
Judge, there was one in the file Friday that the prosecutor had signed off on recommending $100,000 bond.
All right, so first things first. This case, you all you all have been doing discovery since January of 2025.
Yes.
So your plea deadline date for this case is going to be
And just for the court's recollection, Judge, the discovery issue involved the fact that his particular case is rolled over into a murder case.
Okay.
And so that it's never been available through e-discovery.
All right, so your plea deadline date is going to be October 2nd. And so I'll take up this motion to set bond. And Norma, if you can do a reset on this case for plea deadline date for the 2nd, please.
And Judge, we're not going to be finished reviewing the discovery by the 2nd. That's
We'll,
later this week.
we'll see what happens.
Okay.
All right, court is calling 2024 CR 009869 State versus Fendicio Gonzalez. Could I have parties announced for the record
Tony Hernandez on behalf of Mr. Gonzalez.
for the defense? I'm sorry, for the defense, Mr. Tony
Tony
Gonzalez.
Hernandez on behalf of Mr. Gonzalez.
All right, and then you're Mr. Gonzalez. All right, we're here for a request that a bond be set. And my understanding is that you all have,
The state's recommending $100,000 bond, Judge, and we're asking the court for about 75,000.
all right, so why is he in custody and not currently on bond?
Judge, as our motion sets out, he was originally on a $50,000 bond. In June, he picked up a possession 1 to 4 and an evading case. He was also set for court a few days after he was arrested. And he felt that he just needed to save some money, save some money for the family, because he knew he'd be taken into custody.
So
And he
chose
did
not
that,
to
yeah.
appear?
He did, Judge, and he was actually arrested at his home about a month ago, Judge. So he wasn't running from his home, wasn't hiding, Judge. He was there at his home when he got arrested.
All right, the court is going to set the bond at $100,000. There's going to be full GPS, waive fees. All right, is there anything else?
Not right now, Judge. Thank you.
All right, thank you. And Norma, if you'll give him his reset form, please.
Thank you, Judge.
You're welcome. Yes. All right, so when you're setting bonds, one of the things you need to consider is whether or not somebody failed to appear. Because you're supposed to set a bond high enough that people will appear, because they will say, you know what? The money that I would spend if I do not show up is a lot. Yes. All right, the court is calling 2025 CR 008817 State versus Ronnie C. Demas. Can I have parties announced
Good morning, Judge. Ted Wood here for Mr. Demas.
for the state? All right. This hearing was called at 9 a.m. It is now 10:01 a.m. The defendant has not answered docket. Deputy, did you make an announcement for Ronnie C. Demas?
Yes, ma'am.
And what were the results? All right, defense, have you had any contact with your client?
I have not, Judge, although I've been informed that he's Miss Chacon's husband, so maybe she can have contact with him. She says she hasn't seen him in 20 years, but they're related.
All right, so I cannot believe you would try to say, Ms. Chacon, he is putting your name on the record. All right,
Seen him in 20 years. There's not any idea where he is.
all right. State,
Yes, sir. We're asking for a bond forfeiture in the judge's warrant.
all right, what the court will do is the court will issue a judge's warrant. The court will remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
Thank you.
May I be excused, Judge?
Yes.
Thank you, Judge.
All right, Melissa Paez.
Yes, Your Honor.
All right, and it's my understanding she has a motion to revoke as well.
Yes, Judge.
All right, could I see the motion to revoke, please?
Judge, it was not on the CLO's docket today. So she has not produced, there's no MTR at this point. That's why I'm approaching, see if we can reset this.
All right, state, on this case, is there going to be a motion to revoke on this case or no? I don't have it listed as her having a probation matter. It's page 4.
Whether there's a motion to revoke, is that correct?
Well, I mean, is she even on, are you on probation? No, so she doesn't have a probation case.
Okay.
All right, thank you for clearing that up.
Yes, but I still want to.
All right, so, council, she doesn't have a motion to revoke. Have you conferred with the state?
I'm in conference.
All right, so just have a seat. Juan Martinez.
Yes, Your Honor.
All right, if you all come forward. Well, if parties are ready to proceed, defense has filed a motion for a bond reduction. State, have you had a chance to review it?
Judge, not yet.
All right. Or either you all can come back tomorrow.
Judge, I don't mind coming back tomorrow on that.
Okay, all
We're
right,
here-
so,
We're here principally today on discovery issues.
all right, so any other discovery issues?
Judge, on the last setting, the state gave me, this was 18 August, they gave me 94 images, 98 videos, and 431 PDF files on essentially the co-defendant on this case. And I've looked at all of it now.
Okay,
Okay, but there's nothing in there that shows an image of my client in any of that discovery. The lead detective on that case, who was working undercover, claims that my client was at a bus station and got into the main suspect's vehicle and then went to another bus station and
so
got
you're
out
looking
of
for
it.
that discovery.
Say again, Judge?
You're looking for that discovery
I'm
if it
looking-
exists?
I'm looking for any discovery that would show an image of my client, whether it's at the bus station, either of the two bus stations, or whether the undercover detective took a photograph or a video of him getting in or out of this alleged vehicle.
All right, so state, in regards to that, how long will it take for you to find if that information exists?
Judge, I would request about 3 weeks. Mr. Featherston did get with me last week and I did ensure that we provided him all the discovery that's related to the co-defendant. However, it's gonna take me some additional time to get with the detective and see if this stuff exists or not.
All right, Ms. Ferguson, I need a 3-week reset. This will be final discovery on Juan Martinez, please.
Your Honor, I have one other issues to make the court aware of.
Yes.
I have filed a motion for a identification involving my client. The last time I did this was in front of Wayne Christian in 1999, where we did an in-court during the trial lineup to see if the detective could identify my client, not sitting at the table. I've ginned up that motion for this court, but there are now two procedures. There's that in-court lineup procedure, or there's the procedure in the Code of Criminal Procedure that is a 7-photo lineup.
But let's do this. Let's see where we are in discovery
Okay?
first. Because who knows, maybe discovery will show nothing, maybe it will show everything. So
Indeed.
let's come back in 3 weeks for discovery, then we can figure out whether or not a lineup should be done or not.
Great, super.
All right, so a
and-
3-week reset. All right, so we're gonna come back on October 20th for discovery issues. And then with the bond issues, we can come back on that tomorrow if you
Yes,
have
sir.
witnesses.
That would fit my schedule if the court will allow.
All right, and so we'll come back on the bond issue for tomorrow.
Thank you, Judge.
All right, thank you so much. Thank you.
May I be
You too.
excused?
Yes,
Thank you.
you're welcome. All right, Melissa Paez.
Judge, we have a right here on the 2025-008396.
Yes, so what is happening?
It's a file case. She's picked up 3 new cases. So the state needs to, we can reset it for a discovery and also global offer.
All right, state, how long is this gonna take you? All right, Ms. Ferguson, I need a 2-week reset for discovery.
What? 13th?
All right, we're gonna bring you back on October 13th. I'm sorry, what? All right, so once a motion is filed, then the court will take up any motions that are filed, okay?
We'll
All
call
right,
that later.
thank you.
Thank you, Judge.
You're welcome. Jeffrey Dollar,
Good morning, Jennifer.
Good morning. How's it going?
Well, it's going. It's Monday. All over the place.
Yeah, it is Monday.
For a couple of weeks.
If I can make it through the day,
There's.
so Judge, I conferred with Melissa on this case.
Mhm.
So he's got the pending indicted case. And there was a PF case that Melissa contacted intake for. That if we work anything out, we want to try to do it at the same time. The other one is a engage in organized crime charge. And
All right, so this was scheduled for plea deadline date today.
correct, yeah, so what I was gonna ask for is a new plea deadline. So if we can hopefully get that other case and work everything out at one time.
All right, so state, you need to bring this case down. Because this is being recalled back for the final plea deadline date on October 2nd. All right, thank you for addressing appropriate for court. Once you sign the reset form, you're excused.
Is that Monday or Tuesday?
That is Thursday.
Thursday, okay. Oh, okay.
Yes.
All right.
Norma, if you give him reset form for October 2nd.
Oh, that's you, right.
Troy Moore,
Good morning, Judge.
good morning. How's it going?
Good. Thank you for recalling this. Had 7 settings Friday. I have 7 today. I'm just trying to I didn't get here.
Oh, hey, that's okay. You know, I tell her all the time when we were brand new attorneys, even though you can't be in 2 places at the same time, you still try to you try to mess with the time continuum and make it happen, and it doesn't happen.
I usually start on the 4th floor and work my way down, but that day I didn't. This is Mr. Moore's first setting. The state did make us an offer. We're going to talk about it. He has a case pending in a different county, and I'd like to talk to his attorney there to see if I can best help him avoid like double time. So.
All right, Ms. Ferguson, on this case, I need this recalled in 2 weeks for a plea deadline date.
Sounds good.
And be sure to put a hold on him for this county.
October 13th. Okay.
All right, we'll bring you back on October 13th.
Thank you, Judge.
All right, thank you.
Have a seat.
All right, so sometimes you have people here who have out-of-county cases, and you try to put a hold on them here, because sometimes other counties, they will get them back, and then maybe they'll release them. And then sometimes other counties don't have the Zoom capabilities, so it takes forever to get them back. We're gonna try to, oh, she's on page 4. All right, Loretta Ramos. All right, so good morning. Thank you for dressing appropriately for court. So where are we on discovery?
We have discovery, Judge. This is the first setting. We just got an offer from the state.
All right, Norma. If you recall this back in 2 weeks for a plea deadline date. All right, we'll be back on October 13th. Once you sign the reset form, you'll be excused, and I'll need you all to do an acknowledgement of discovery before you leave.
Okay.
All
thanks,
right,
Judge.
thank you. Joshua Mackay. Is this a motion to revoke?
This is a motion to set bond on a motion to revoke. I have it right here.
All right, and could I see the motion to revoke, please?
Morning.
Good morning. All right, court is going to call 2014 CR 5495 State versus Joshua Mackay. Can I have parties announced for the record?
Ashley Jones for the state.
And Kelly Piddle for Joshua Mackey.
Oh, it's Mackey? All right, I'll try to remember that. The I is throwing me off. And you're Joshua Mackey?
Yes, ma'am.
All right, the defense has filed a motion to set bond. State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense.
Judge, we're asking that the court set the bond at $5,000. Mr. Mackey has 3 allegations in MTR, one of them being an assault case out of Harris County that is an assault choking, $4,000 in restitution, and a failure to report in the month of March of 2025. Mr. Mackey would ask the court to set the bond at a lower number so he can pay back the restitution that is owed to the court rather than paying a high bond amount, and foregoing paying that restitution. In addition, this case is, he's been on probation for 10 years. And the case is expired except as for this MTR. So we asked the court to set out a lower bond amount so that he can bond out and pay the restitution to the court.
All right, state.
Yes, Your Honor, this is the defendant's second MTR. As the court noted, he had one in 2024, where one of the allegations was that he had a firearm. This MTR stems from drug use, not reporting, and felony violent offense. The state does understand that he is or should be expired. However, it seems like the defendant has relapsed into behavior since early of last year. And presents danger to the community, specifically committing any violent felony offense. And so the state would recommend that the bond be reverted back to its original bond, which was $75,000, GPS installed, and prejudice ordered, and there be no contact order with that.
We are in agreement to the no contact order to the GPS judge. The previous MTR was withdrawn by the state.
That is correct, Judge.
All right, we're gonna go off the record. Oh, Anijah Gifford. Good morning.
My client should be on Zoom.
Yes, she's on Zoom. And let me see.
Hello,
Hello,
good morning.
good morning. All right, so state, were you able to tender an offer in this case? And is your client out of county? Are you in another county or you're just at work?
I'm in Georgia and I'm also at work.
All right, thank you.
Sorry.
No problem. So
Yeah.
what we're gonna do is we'll set this for a plea deadline date. And Ms. Ferguson, I need how old are you?
I'm 27.
All right, Ms. Ferguson, I need a 2-week reset for a plea deadline date. All right, so we're gonna be back on October 13th and you can appear by Zoom.
Okay, yes, ma'am.
All right, thank you. And thank you for dressing appropriately.
Yes, ma'am. Thank you.
Yes.
Thank you.
All right, who's here on Worley?
I am, Your Honor. Eric DeWalt.
Okay,
He was set last week. He walked to court.
yes.
They missed his court date, so y'all allowed him this time to show it via Zoom. Thank you.
You're welcome. All right, so on this case, what are we here for?
Your Honor, it's just a restitution hearing. I believe there were some IDs that were found in the car. The state, I believe, was going to withdraw the restitution hearing.
All right, state, so on this case, is there any outstanding restitution?
Judge, we've given all the victims an opportunity to be heard. We only heard back from one of them, and they stated that it was just the ID, no financials attached, and so at this time, we don't have any documentation for restitution.
All right, Ms. Abrams,
Yes, Judge.
on this case, Mr. Worley, on page 12, number 2, restitution is waived.
Thank you, Judge.
All right, thank you.
Good luck, Mr. Worley. Judge, thank you very much for your consideration.
All right, Mr. Worley, probation will be calling you.
Thank you, Judge. Now, the-
Yes, you may be excused.
Sorry about that. My phone was muted. I couldn't get it unmuted, but thank you, Judge.
All right, sure. Make sure you call probation, all right?
Okay, I've already met with them once and we have another meeting coming up, but I'll go ahead and call them.
All right, thank you.
Thank you.
All right, Mills? She's not here.
She's not, Judge. I know she's had a couple of pretrial violations too for reporting.
All right. Are there any pretrial motions on her?
They were pre-indictment.
Okay. All right, the court is calling 2025 CR 00818 State versus Christina Bell Mills. Can I have parties announced for the record?
State,
Will Brooks for Miss Milford.
All right, have you had any contact with Ms. Mills?
I have not had any luck contacting her, Judge.
All right, this hearing was scheduled at 9 a.m. It's 10:34 a.m. The defendant has not answered the docket. State.
Your Honor, we would ask for a bond.
All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you, Judge.
All right, thank you.
Can I be excused?
Yes.
Thanks, Judge.
So that's four now.
Kenneth Thompson. Is he out here?
He's got it. Can he just sit there?
Yes.
Stay there.
All right. What is happening with this case?
We're unable to reach an agreement after a trial.
All right, do you have all discovery?
Yes, ma'am.
State, I'll need a discovery acknowledgement.
Yes.
Mr. Thompson? All right.
Speak loudly, Your Honor. He can't hear.
Oh, you're unable to hear me? All right, so you have a choice of a jury trial or a bench trial. If it's a bench trial, it will come to me and I will hear whatever evidence is presented by the state and make a decision on whether you're guilty or not guilty. The state will also have to agree to waive a jury trial, or I can set this for jury trial. What, do you want a jury trial or a bench trial? I'm sorry? A judge trial? Oh, I'm sorry. So a bench trial is where the state will present whatever witnesses they will present. I will listen to them and I will make a decision on whether you're guilty or not guilty. If the state proves its case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. A jury trial is where 12 people will sit. The state will still have to call witnesses, and those 12 people will listen to the evidence. And if they can come to a decision, they will make a decision. So do you want a bench trial or a jury trial? All right. How long do you all anticipate this trial?
2 days.
2 days? All right, Ms. Ferguson, 2 days? All right, December 9th. They'll have you brought over dressed for trial.
Excuse you, Your Honor.
Yes. Oh, after you sign the acknowledgement. All right, Kelly Piddle,
Yes, sir.
are you all ready on your case?
Please, sir.
All right, so we're going to go back on the record. The court is going to, as previously stated, the court will set your bond at $50,000. Partial GPS for employment only. So that means you're only allowed to work while on GPS. GPS fees will be waived. There's to be 30 sober support meetings in 30 days, and there's to be no contact with the complainant in the out-of-county matter. And is he living in Harris County or no?
He lives in Harris County.
Okay. All right, is there any other requests for conditions, state?
Not from the state, Your Honor.
No.
All right, Ms. Ferguson, I need this call back in 10 days for a contested hearing.
October 9th.
All right, your contested hearing is going to be October 9th. Probation, this is a true contested for October 9th. All right, thank you.
Thank you.
Jose Alvarez.
Yes, Your Honor.
Hello. All right. Thank you for dressing appropriately for court. All right, counsel, have you conferred with the state?
I was able to briefly, Your Honor, I don't believe they have the labs back yet, and I was just hired a week ago. So I would like to.
We could just have a couple of minutes because they are on the discovery leaves.
Okay. All right, so if you all step back for a moment and then just let me know when you're ready to approach again.
Yes, ma'am.
All right, thank you. All right, Mr. Alvarez. All right, so where are we on discovery?
The state was able to show me the labs, Your Honor, and looks like they're available on the e-portal. I'm going to provide the state with there's community supervision paperwork out of Guadalupe County. And so we can hopefully come to a disposition or resolution.
And state, were you able to tender an offer?
Yes, I gave like a rough offer, but we're gonna confer between now and the next. But discovery is, she's just gonna provide me with like something that would most likely change my offer.
All right, Ms. Ferguson, I need a 45-day reset, and that'll be your plea deadline date.
Thank you, Judge.
Do worship.
Then maybe big excuse.
Oh,
Once we sign.
yes. Oh, what's the date?
November 13th.
All right, it's November 13th. Jan Madeira, are you all ready?
Judge, we're still working on some discovery.
All right, so your client needs to be up here.
Jan?
What discovery is being worked on? Because today is the final discovery day.
So we've got a few things that the complainant has brought us, some audits from 2017, 2018 that we wanted to look at. They're undergoing renovations at the main office, and so their scanner's out of commission, so I'm still working on getting the defendant's personnel file and any of the supporting documents that were specifically requested for that were used in making the audits.
All right, so what I can tell y'all been doing discovery since July. This is going to be the last date for discovery. I will not extend discovery any further. You're coming back on October 13th. That's your final discovery date. All right, once you sign the reset form, you're excused.
Right, and Judge, can we have at least till the end of October?
No.
I think we have a few things that if we can get worked out, we can take care of this case completely, but just a little more time would be helpful.
No, I mean, y'all have been doing discovery since July.
It's a complicated case, Judge.
I understand. Your final discovery date is October 13th. The court will not give any further extensions for discovery. And on that date state, you'll need to be prepared to tender an offer.
And we've been kind of spitballing offers.
Okay.
A lot of them are conditioned on upfront restitution, so that's sort of what we're working towards today.
All right. Yeah. All right. Thank you. Thank you for addressing appropriately for court. Once you sign the reset form, you'll be excused. Thank you.
Thanks, Judge.
Joseph Alamon. And counsel, are there any applications?
No, Your Honor.
All right, the court is calling 2025 CR 003-507 State versus Joseph Alamon. Could I have parties announced for the record?
Galley from State.
Adam LaHood for the defendant, Your Honor.
And are you Mr. Alamon?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have, and we did receive it, Judge.
Court will find that the state is in compliance with discovery. Mr. Alamon, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Following the injury.
We have no objections, Your Honor.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, the state is proceeding on the lesser included offense of assault bodily injury as a Class A misdemeanor. The range of punishment is up to a $4,000 fine and up to 1 year in the Bexar County Jail. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he's competent and was sane.
Mr. Alamon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand by entering this plea, if you're not a U.S. citizen, you could be deported, not allowed naturalization, and denied re-entry into the country? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 365 days in the Bexar County Jail. The state is proceeding on the lesser included offense of assault as a Class A misdemeanor. and there's a $2,000 fine. Did you understand that to be the plea? Defense, is that the plea?
It is, Your Honor.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that there be no contact with Stephen Blackstone or Savannah Villalobos. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
It offers states one in.
No objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty. And the court will find you guilty. State, have you had a chance to speak with the complainants? Have you had a chance to speak with the complainants? Okay, all right, thank you. All right, are you waiving PSI?
We are, Judge.
Anything you wish to say on behalf of your client?
No, Your Honor. I know the plea calls for 365 days. I believe he has over 250 days or so, about or thereabouts. We're hoping the court will see fit to judge him satisfied.
All right, so I'm not going to judgment satisfy you because you don't have 365 days. The Bexar County Jail, they're in charge of people receiving 2 for 1 or 3 for 1. Usually if you're in general population and there have been no issues, for every day you serve, they'll give you credit for 2 days. If you're a trustee, for every day you serve, they'll give you 3 days. The only thing that can stop them from giving you 2 for 1 or 3 for 1 is their own rules and regulations, right? Or I can tell them, no, I want you to serve the full 365 days with no 2 for 1 or 3 for 1. Do you understand? So what I can tell you is the most time you will serve will be 365 days. Do you understand? All right, as previously stated, the court is finding you guilty. The court will sentence you to 365 days in the Bexar County Jail. There's a $2,000 fine, time and money. We're run concurrently. The court will give you credit for any time served. There's to be no contact with Stephen Blackstone or Savannah Villalobos. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. When you go to somebody else's house and y'all are drinking and it's a house party, just leave before anything happens. You understand? All right, good luck to you. You're welcome. Maria Cisneros.
Judge, I'm here for her. I just called her bondsman, reaching out to her. But he says she's been checking in, so he does not understand why she is not here this morning.
All right, the court is calling 2025 CR 009530. State versus Maria Cisneros. Could I have parties announced for the record?
Marshall D. White from Miss Maria Cisneros.
All right, this hearing was scheduled at 9 a.m. It is now 11:02 a.m. The defendant has not answered the docket. Defense, have you had any contact with your client?
I have not, Judge. As I just indicated off the record, I did just reach out to her bondsman, and he indicated to me that she has been reporting in, and that he's going to make an effort to reach out to her, see what may be the problem.
All right, state. All right, bond forfeiture will be granted. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you.
All right, thank you.
Yeah, I'll be excused.
Yes.
Thank you, John.
All right, Viviano Segundo. All right, so where are we on discovery?
Judge, there might be a surveillance video that I'm gonna request from the state. This is a first setting, so it's a regular reset, so I can confirm all that, Judge.
All right, Ms. Ferguson, set this for a final discovery in 30 days, please. And state you'll need to be prepared to tender an offer at that time. All right, we're gonna come back on October 30th. Thank you so much for addressing appropriately for court. Just have a seat and your attorney will bring the reset form to you. Once you sign it, your excuse. All right, thank you.
Thank you. Thank you, Judge.
You're welcome. Court is calling 2025 CR 009598 State versus Andre Renee Oeda. Can I have parties announced?
Roberto Ambrosino for the defense.
All right, this hearing was scheduled at 9 a.m. It is now 11:04 a.m. Defense, have you had any contact with your client?
I have not, and I've made an effort to get in touch with him.
State?
Has the bond forfeiture now?
All right, let me see one moment if he's on a commercial bond. Just one second. All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Thank you.
Jonathan Navarro. All right, where are we on discovery?
Well, address that it's a first degree. I'm not on the wheel.
Ah, all right. So what's going to end up happening is a new attorney will be appointed to represent you. Just have a seat.
Thank you.
Oh, and he's a Spanish speaker. All right, Norman, he's a Spanish speaker, and we're going to need a new attorney appointed to him. So Deputy Laura, if you can tell him in Spanish to have a seat and we'll get an attorney appointed to represent him. Yes. All right, DeLeon, who do you have? And then I'll take you up next. And I'm sorry, the last name is Vargas.
Carter.
Let me just find him on the docket. All right. So where are we on discovery?
Judge, this is a blank hearing.
Ah, okay, let me pull it up. Thank you. Any objections to the court reviewing the summary?
No objections, Judge.
Judge, I don't believe you have a court summary. I
Okay.
do have the latest supplemental report
All
that
right, if I
was.
can have that.
That'd be perfect.
All right, so there's a recommendation for you. The recommendation. And Miss Abrams
Yes, Judge.
and felony drug court, they're full still?
Judge, let me confirm the outcome for the larger.
So we're gonna see what the outcome was for felony drug court. The last time felony drug court was full.
Yeah.
And that was previously recommended for him. And for me to recommend that, that means that there's some issues. So everyone wants you to be successful at probation, and you're not gonna be successful if you don't get control of this drug issue. Yes?
I'm gonna print out that.
All right, thank you. Because there's a recommendation for you to go to SATA.
There's Judge, we wanted to address that.
All right, so it appears that the prosecutor in felony drug court did not want you in felony drug court, so they believe there are other issues. Also, they were full at the time. But felony drug court and the top evaluation is recommending inpatient treatment. They're recommending either you go to lifetime recovery or you go to SATA. And you wanted to address that?
Judge, we wanted to, well, he was placed on 5-6 years deferred, approximately 90 days. He had the tap gun in custody, and he's been a reliable trustee. He worked 6 or 7 days trustee in jail. He wanted to have the opportunity for outpatient treatment potentially because his father's in Northeast Baptist Medical. He's 82 years old. He knows this information because he calls his father's cell phone, and family members have told him, you know, what the situation is right now. His prior, he had one prior approximately from the top of my head, 10 to 12 years ago, deferred, successfully completed it. So what we would like to do is to place him in an outpatient treatment program with any and all conditions to monitor to make sure he's not doing any drugs or anything like that. He assures me that he will do whatever the court wishes to do on that front. I'll also want to give him an opportunity to speak to address the court.
So here's the thing, I'm reading the supplemental report and it says that you're not in agreement with the recommendation because you don't feel you were given an adequate opportunity in court to be allowed to explain your circumstances. The explanation of your circumstances is the TAP evaluation. And the TAP evaluation is done by experts and they feel that you need inpatient treatment.
The TAP evaluation was done after I'd been incarcerated for about 20 days, and I'm not really someone that's like been in jail before like that, so I feel like my answers were the fruits of my frustrations and just like not really actually bearing the truth, you know, so I mean, like.
No, here's the thing. No, when people do these treatments and they say, oh, I'm in inpatient treatment, or I've been without drugs for 20 days.
Yeah.
When you're a heavy drug user, the reason why you're not using drugs is because
well,
at the Bexar County Jail, I'm sure there are ways. However, you haven't found those ways and you're on lockdown.
Understood. The thing is that like I really feel that these 3 months being in jail, I've like kind of opened my eyes and like really made me understand where I want to stand as far as like what's
But
the
Judge
law.
Brenny says you've been on probation before, so haven't you always known where you should and did not want to be?
I admit I'm not perfect. I mean, I completed my probation. I feel like I'm a perfect candidate for probation because I completed it before. And I mean, I just feel that like an inpatient program would be more hurtful than helpful just because of the fact that my dad's in the hospital right now, not doing very
So
good.
here's the thing. Why didn't you think of that all before you committed offenses? And the perfect candidate for probation is someone, if they were previously on probation and they really learned things, they would not have another probation after the fact.
It was, my mom passed away and it was a poor judgment, poor choices that I made.
Now,
And
see, here's the thing. People need to stop blaming
yeah,
their choices on outside actions.
Judge, I will say that prior was over a decade ago. So I've been, he manages, I'm sorry, he manages commercial properties. He's got a full-time job as a, what's your full-time job?
I work at newspapers and education. I'm a community outreach coordinator. We call businesses trying to get them to donate to schools around the area.
So he's got a full-time job, Judge, waiting for him. You know, I know the court is not too sympathetic to that, but at the same time, with alternatives, if he were in outpatient treatment and he was tested bi-weekly or something like that, you know, I think that would assure the court that he's not doing any type of drugs. So
Well, I'm always sympathetic and empathetic, but I still look at things objectively.
Judge, the last thing that's on my mind right now, like really, like I feel like if I can be with my father during this time of need, it would give me some like peace of mind. Because I mean, if I have to do inpatient program and I can't be with him, it will really just send my life into a downward tailspin.
Well, and see, that just tells me you don't know how to cope with things in your life, because if something bad happens, that doesn't mean your life goes in a tailspin. Let me use drugs.
No.
Probation, what are you requesting?
Judge, based on the supplemental report that was submitted, the option one was to hold Sept in abeyance and for him to do intensive outpatient treatment, monthly UAs, and sober support meetings. I'm not opposed to that. I would say instead of having it monthly UAs, maybe we put them on the IVR hotline and intensive outpatient. And then sober support meetings daily for 60 days. With the understanding that if anything happens, any positives or anything comes up, then he would go into inpatient treatment.
No, if any positives or anything comes up, a motion to revoke is going to be filed.
He understands that, Judge.
All right, the court will alternate meeting conditions. It's going to be the IVR hotline until further notice, 90 sober support meetings and 90 days in intensive outpatient treatment. Is there anything else you need from the court?
We thank the court.
All right, thank you. All right, and then, hi. Oh, I'm doing great. And let me see, what was the name of that person, Miss? It's funny. All right, Jonathan Navarro. And we're recalling him tomorrow, correct? All right. Your previous attorney, Mr. Trevino, was appointed to represent you, but he is not on the list to receive appointments for first-degree felonies. So there is a mistake in the system where he was appointed. We're going to bring you back tomorrow, and we will make sure that there's an attorney here for you who speaks Spanish and who is on the first-degree appointment wheel. Do you have any questions?
Why am I getting first degree?
Because the case that you've been indicted for is a first-degree felony. And it's best that you speak to your attorney who's going to be appointed to you about the charge and any evidence the state may have.
All I can say.
Que me comparen las edades, que miren bien los mensajes.
To compare the ages to look at.
No, no, no. Here's, do not talk to me about what you think the facts of your case are. That you'll need to speak to an attorney. We will bring you back tomorrow and you can address it with that attorney. All right, thank you.
Your Honor, may I be excused?
Yes, you may. Thank you so much.
Thank you.
Crystal Velaz. All right, the court is calling 2025 CR 006953 State versus Crystal Velaz. Could I have parties announced?
Danny Gutierrez for the state.
Roberto Ambrosino for the defense.
And are you Ms. Velaz? Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the application for deferred adjudication with your attorney? Did you understand it and did you sign it? Did you review the true bill of indictment with your attorney?
Yes.
Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right, let's go off the record. Are you all only charging on count one because the court's docket has 3 different counts in it?
There's 3 counts in the indictment, Your Honor.
So are you proceeding on all 3 counts?
All 3 counts are part of the plea, yes, Your Honor. Maybe it's like 2 of them need to be closed out, they're separate in Odyssey, is that what you're saying?
No, I mean, if y'all are proceeding on all 3 counts, then y'all need to, so that the record can be clear and so that we're off the record, so that the record can be clear and she can know what she's pleading to. If y'all are proceeding on counts 1, 2, and 3, do y'all agree there are 3 counts?
There is, I mean, it's supposed to be deferred, so I mean, it should.
No, I mean, she'll need to enter a plea to all 3 counts, and if all 3 counts are the same level felony,
Yeah.
y'all need to put it in your plea paperwork. Okay, so if y'all will step back, and when you all are ready, I will take you out. All right, Reginald Green. Morning.
Good morning.
All right, what is happening with this case?
Your Honor, Mr. Green has a motion to revoke or a motion to enter adjudication.
Yes.
I have met with his parents on Friday, the end of last week, and they actually retained my office to represent Mr. Green on this. I conferred with the probation department and with the district attorney's office. They were both in agreement with allowing a reset with the court's permission to kind of get up to speed. The NTR alleges new misdemeanor condition 1s. I'd like a chance to get some discovery and kind of prepare for those
there's a chance we could get it worked out. More importantly, I think in discussing his situation with his family and this morning with him, it's my belief, and I think I speak for the family as well, that if the court would consider a mental health evaluation, there is a very distinct probability that there's some underlying mental health issues that need to be addressed.
So do you believe he's competent?
He's competent.
Okay. All right. So this is going to be recalled back on October 6th for a contested hearing. All right. Thank you.
Thank you.
You're welcome. All right. We're back on the record. The court is calling 2025 CR 006953 State versus Crystal Velaz. All right. And my understanding states you're proceeding on all three counts?
Yes, Your Honor.
All right. So did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right. You're charged with misappropriation with a fiduciary duty of financial property, 2,500 to 30,000. Money laundering, 2,500 to $30,000. And securing a document through fraud, 2,500 to $30,000. All of those are state jail felonies. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. That you intend to give up those rights and enter into a plea in this case? I'm sorry? Yes, ma'am. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine in each count? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Velaz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? No, ma'am. Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, not allowed to re-enter into the United States and denied naturalization. Do you understand? The court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on counts 1, 2, and 3. There's a $500 fine to be probated. Counts 1, 2, and 3 were run concurrently. The state is recommending deferred adjudication. There's to be restitution of $17,215.37, of which $5,000 is to be paid before the court sentences you. And that is to be payable to Calton, CALTON Investments, Inc. Did you understand that to be your plea? Defense is at the plea.
Yes, Your Honor.
State is at the plea. Yes, sir. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Yes. Counsel, are there any such motions?
There are none.
Outside the agreement, the state is recommending that your community supervision be for a term of 5 years. There be a TAP evaluation, 96 hours of community service restitution, no contact with 400, is this an M or N?
It's an N, Your Honor.
400 N apartments, Springwood Apartments, Trina Meyer, Delia Brodniks, Marilyn Meyer, and Brent Meyer. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? Then to count 1, how do you plea? Count 2? Count 3? State any evidence to support the defendant's plea?
And at this time, Your Honor, state offer states that there 1, I believe it's already in front of me.
No objection.
All right, did you review the document entitled waiver and consent to stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of account 1, 2, and 3. Court will defer finding of guilt as you've applied for deferred adjudication. So when are you going to be able to pay this money back?
I'm sorry?
When will you be able to pay?
Monthly.
She was able to come up with 5,000 upfront that she has today.
So when are you going to be able to pay this back? How much are you thinking you can pay per month?
I think I can pay at least $400.
So this is what the court is going to do. You've paid 5,000 so far. Has that already been paid?
She has it with her and she's gonna.
All right, so.
They haven't turned it over to me yet, Your Honor.
All right.
Because they didn't ask for it, but we do have it.
All right.
That's fair.
Yeah, we have.
They're not. I didn't fill out.
All right, and is that 5,000?
Your Honor, just for the record, it's 2 money orders, both in the amount of 2,500 each.
All right.
And they are made out blank, so they could be.
Just what I instructed.
All right, so when are you able to come up with $2,215.37? I'm sorry, what?
Maybe December, a little before.
All right, so I'm going to bring you back for sentencing. And I'll notate that you've already paid the $5,000, but you're coming back for sentencing. Norma, set this for the last date that we are, well, it set it for the beginning of December. All right, so we're coming back for December 1st for sentencing. At that time, you need to be prepared to tender $2,215.37. All right, Ms. Ferguson will give you a reset form. And I'll see you on the 1st. Jesse Ramos.
We're present, Judge.
All right, if you'll come forward, please, and your client.
You just sign something.
All right, so today is plea deadline date. So are you all reaching agreement or?
We have an agreement offered. It can change substantially. Because we found out this morning that there could be some restitution on the tune of 5,000 or maybe a little bit more. That I got a commitment from my mom, from the grandma, from my client, that they're willing to come up with that money. It's over $5,000.
All right, I'll recall it for final plea deadline date for October 6th.
Well, that's the second part.
Mhm.
My family is asking if there's any way you can give them 30 days to come up with that. It's 5,000. Just, the DA is not in opposition because they want to give it.
No, the only reason why, because this has been set out for a plea deadline date since October, so it's already been a month. So October 6th. Okay. All right, once you sign the reset form, you're excused. All right, thank you. Thank you for dressing appropriately for court. Austin Gibson. All right, is this a motion to revoke?
Yes, Your Honor.
Okay. So I see the motion to revoke file, please. On Austin Gibson. Of the probation, because this is a motion to revoke, so I need the file on Austin Gibson.
Sorry.
Court is calling 2019 CR 8096 State versus Austin Zachary Mark Gibson. Can I have parties announced?
Megan Galloway for the state.
Andy Fred, Mr. Gibson.
And are you Mr. Austin Zachary Mark Gibson?
Sure.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney, and did you understand it? Are you the same Austin Zachary Mark Gibson who was placed on deferred adjudication in 2019 CR 8096 for the offense of aggravated assault with a deadly weapon on February 21st, 2020 for a period of 7 years? Is that you?
Sure.
All right, state.
Violation of condition number 1, on or about the 31st day of August 2025 in Bear County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal trespass, a violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Violation of condition number 1, on or about the 31st day of August 2025 in Bear County, Texas. The defendant, Austin Zachary Mark Gibson, committed the offense of criminal mischief, $750 to $2,500 in violation of condition number 1.
How do you plead to that? True or not true?
Not true.
Did you understand by pleading? Oh, I'm sorry, you all are wanting your contested, right?
That's it, Judge.
All right. We're going to set this for a contested. At that time, the state will bring witnesses. I'll hear evidence and I'll make a decision on whether or not the violations are true or not true. Do you understand?
Yes.
All right, Ms. Ferguson.
Yes.
I need a 10-day reset. Is that enough time for everyone? For a contested hearing?
More than enough time for us.
That's October 9th.
All right, October 9th will be your contested hearing.
Judge, I have a conflict on that day. I'm gonna be in Houston that day. I'm available on either the 10th or the 8th.
Yeah. All right, Norma,
Literally any other day but that.
he's out of county. Are y'all able to do it October 7th?
Yeah.
Or the 6th? Ms. Abrams, it's gonna be October 7th for a contested. All right, thank you.
Thank you, Judge.
You're welcome.
Have a seat, sir.
Walter Prince.
Yes, Your Honor.
Hello, Mr. Prince. All right, so Mr. Prince, docket starts at 9, so you need to make sure you're here on time, all right? Let me see here.
I believe it's a final discovery, Judge.
All right, Odyssey is moving slow.
I had something with Odyssey last week. It wasn't showing me some cases that the DA was looking at.
All right, so where are we on discovery?
I believe I've got everything that the DA has to offer, Judge, at this point in time, and we do have an offer. Mr. Prince is getting me some documents yet, but that's not the DA's burden. It's Mr. Prince's.
All right, if you'll make sure you sign the acknowledgement of discovery before you leave.
Yes, Your Honor.
Ms. Ferguson,
Yes, ma'am.
I need a plea deadline date for this case in 20 days, please.
Yes.
All right, once you sign the reset form, you'll be excused. Just have a seat. Your attorney will bring that to you.
Thank you, Your Honor.
All right, who else is ready? Kara Henry? Henry?
Yes.
All right.
Hello.
Hello. So what are we here for?
It's a first setting. Judge, I conferred with the state.
All right, do you have all discovery?
I believe I do, Your Honor.
All right, state, if you will do an acknowledgement of discovery, and state, were you able to tender an offer?
We're under a tentative offer. The state just needs to reach out to the victim to determine if there was any financial harm.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date. All right, and you can appear by Zoom. And also make sure you do the acknowledgement discovery on the 2 cases because she has a second case as well.
Yes, Your Honor.
All right, thank you. Once you do that, you are excused.
Thank you, Judge.
Thank you.
You have a good day.
All right, and Ms. Henry, you're excused.
Thank you. Have a good day, Judge.
You too. Thank you.
Mhm.
Yes. All right, Andrew Reyes.
Present.
All right.
Mr. Reyes is here.
Mr. Reyes, come down. Oh, hi, Mr. Reyes.
Oh, Your Honor.
So,
Judge, we have a plea bargain. We've been extended. We've got the paperwork done. When I turned it in, the clerk informed me that I have to come back at 1:30.
all right, has he been sworn?
No, I haven't.
No, he hadn't sworn in. But I have a doctor's appointment I have to get to, Judge. I was trying to get out here by 12:30 to make sure I get over there. So I can't come back. Would we possibly come back either tomorrow or Wednesday? Wednesday probably
Tomorrow.
would be better with my client.
Tomorrow.
Okay.
All right, Norma, recall them for tomorrow. And if you'll stay here so that the clerk can have you sworn in.
Thank you, Judge.
All right, thank you. Gerald Harper. Court is calling 2025 CR 009537. State versus Gerald Harper. Could I have parties announced for the record?
Then, Tim Molina from Mr. Harper.
All right, this hearing is scheduled at 9 a.m. It is now 11:49 a.m. Council, it's the court's understanding that your client is not in jail, that they now do virtual booking. And your client has not made an appearance for the court. Have you had any contact with your client?
I wasn't supplied with any contact information for my client. It's my understanding he was virtually booked in Harris County. I've run, he had an open case there that's closed. I ran TDC. I don't see that he's there. So I don't have any way of knowing if he was aware of the court setting or not, or if he's certainly not present.
All right, state. All right, the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Okay.
Great, thank you. Adam. All right, so Ms. Owen said that she wouldn't be back in town today.
Yes, ma'am.
So if you want to talk to the state and see, we can do jury selection tomorrow, or either we can do jury selection today.
I prefer if Amy was here. Honestly,
Okay.
it's just easier to have a second chair.
Okay.
Are y'all opposed to starting tomorrow? I don't think this case is gonna take more than 2 or 3 days. With or without.
And what is your client's name?
Tell me right. He's here, Judge.
Page 1 at the top, Your Honor.
All right. So
Somebody-
what we'll do is we'll recall it for tomorrow
Yes, ma'am.
and we'll do jury selection in the afternoon.
Okay.
Ms. Ferguson, on Shelby Rodriguez, Ms. Owen isn't back yet, so we're gonna recall it for tomorrow and we'll do jury selection in the afternoon.
We'll be here at 9 o'clock with my client.
All right.
Your Honor, can we make that real quick contingent? I need to follow up with my witnesses, see if they can come, I guess, the following days instead of.
Well, of course they can. Yeah, I'll be able to do it. All right. We'll come back and do jury selection on tomorrow. And if you could give her a reset form?
Yes,
For
ma'am.
tomorrow afternoon, Judge?
Yes.
Or you need to be here?
No, she can be here in the afternoon.
Any other- State?
Yes. You're welcome.
Judge, can we do a PSI, Kimberly?
Yes. And we're still waiting for Arlene Gay. So if you want to, you can do it on another day. And we'll just see when Miss Gay arrives.
Going out into the hallway and trying to call and she won't return my call.
Okay.
But
I mean, there's nothing we can do because that's her attorney.
True, yeah.
Yeah.
I'll reach that it. He's here in custody.
Okay.
Also, the team is wanting to address one of our participants, Lilia, that she's at lifetime.
Okay, so what we can do is if you're able to come back this afternoon for him.
Judge Huff, I have misdemeanor.
Okay, all right, well, we can just put it on another day, okay?
Yes, Judge.
Judge. Can't help those trials. I've been working with Miss Gay, but we completed 246.
Okay.
Maybe to drop her the DM.
Yes, if you could do that. All right, who's here on Kimberly Essex?
Thank you.
All right, the court is calling 2025 CR 004431 State versus Kimberly Renee Essex. Could I have parties announced for the record?
Words for the state.
Michael Bellow from Miss Essex.
And are you Miss Essex?
Yes, ma'am.
All right, you entered a plea to count 4, paragraph A of no contest. You pled true to the enhancement. State waived counts 3, 1, 2, counts 4, paragraph B, and just one moment. Well, this will make it simple. They are proceeding on counts 4, paragraph A, and the enhancement. All other paragraphs were waived. According to the plea bargaining agreement, punishment is to be assessed at 10 years in the prison. There's $1,000 fine. The state opposes your application. Have both parties had a chance to review the PSI and TAP evaluation?
Yes, Your Honor.
Yes, Judge.
And there was also a McMyoff evaluation.
And the McMyoff evaluation?
Yes,
All right, any objections?
no objections.
The state judge.
All right, state, do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
I have one witness, ma'am.
All right, you may call your witness.
Yes.
And if you'll step over to this side, please. Could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
William Essex.
All right, you may proceed.
Mr. Essex, how are you related to Kimberly?
She is my daughter.
Yes, your daughter. So you're familiar with her legal situations?
Correct.
Okay. You're aware of what she's charged with today?
Correct.
And you're aware that she is facing up to 10 years in prison?
Yeah.
Do you feel 10 years is going to help her?
You know, as a father, 10 years, gee, but I don't see at her age what benefit that would be. And as you explained to me earlier, maybe a different scenario would be the D, would you say the mental and alcohol treatment center,
Right.
which sounds really more applicable to this case. I think Kimberly has obviously issues with alcohol and drugs, but also the mental issues have not really been addressed. She feels that she has drugs implanted in her stomach and her brain, just various things that I think she would benefit from the other program in the prison.
All right. Is there anything else you would like to tell the judge?
She's a good person. She just great heart.
I have no other questions.
Any questions?
Just a few, Judge. I'm Mr. Essex.
Oh, yeah.
Is it okay to call you Bill?
Sure.
What do you prefer?
Whatever you just feels fine.
All right, so I know you're Miss Essex's father. And she's kind of had a history of struggles. Is that fair?
Correct.
Back to the mid or the 2000s,
Yes.
theft. Have that intoxication assault, which seemed to be a life-changing event for her.
Yes.
Like she did a little bit for criminal mischief.
I believe so, yes, 16 months.
And sometime after she got out of prison for her intoxication assault, he put on probation for another DWI. Remember that?
I'm not aware of that.
Remember her going back to prison? Subsequent?
No. There's still one time in Houston.
Okay, so you're not aware of anything out of Austin?
Yep. Yes, yeah. Exactly right.
That was, it's like discharged in 21, so.
Correct.
We're talking about decades of substance use
Correct.
issues.
Correct.
And have you personally observed in the last few decades substance abuse issues as her father?
Yes,
You've seen how that affects her behavior.
yes.
And now, are you familiar with the facts kind of the incident case?
More or less, yes.
Now, there's some indication on the front of this, which in fairness, pretrial sentencing officer investigates this to give the court context. Right?
Okay.
Kind of the purpose of all this.
Okay.
They like to view the whole person before the court makes a decision. And they give their impressions sometimes. And the impression that they got is that she acknowledged guilt. But she gave a statement, and the statement seems to indicate that she was given a card to use. And that was just kind of that. Is that consistent?
I wasn't involved. That was my former wife.
Oh, I see. Okay.
Yeah.
So you're not personally familiar with
No.
this? Okay. Now, the plea bargain here is 10 years opposed. So I'm here, now I look at this history.
Okay.
I look at the opportunities that she's received. for
Correct.
Treatment, probation, I
Correct.
think. So she's clearly shown us that she's either not taking it seriously or she's not ready. She hasn't been ready before. So is there anything in this situation here that tells you that this situation is different?
That's a good question, but I don't think 10 years is
I think it's ludicrous in regards to the situation. I understand. So 10 years seems like a large amount of prison time. Yes, it does. So it, from your perspective, maybe a little less than 10 years or some structured rehabilitation facility. Yes. Do you believe there's any other option if we're to hope she has any chance of getting back on her feet? I think the structured rehabilitation is gonna be our last shot. And do you think probation without that structure is gonna work for her based on what you see? No, I think she needs some structure. Okay, yeah. I don't want that's the witness, Judge.
All right, thank you so much for coming down.
Thank you, sir.
All right, counsel, any other witnesses?
Comment.
All right. So, Miss Essex, I want you to know I listened to the testimony that was given by your father. But I've read the PSI report. Are you still, and I don't know if you want to call your client as a witness, she's given up the right to remain silent. But in the PSI, she's saying that she was given the credit card. But in looking through things, she wasn't given the credit card. And what she's spending the credit card on, I mean, there are many things with Dobby nails, going to the dermatologist, going to HEB, going to 7-Eleven, Best Buy, Shell Station, the Alamo Cafe, Best Western Hotel, SQZ, Trip Reggie, Specs Liquor, Crown Cab, and there are Dobby's Nail, 7/22/24, another Dobby's Nail, 7/22/24, all in the same day. Then there's Walmart, then there's Five Below, then there's Specs Liquor, then there's Ross, then there's Sushi Place, then there's FedEx, then there's American Best, Dollar Tree, Burlington, Wine and More, Chili's. So she, KFC, Torchy's, Don and Ben's Liquor. So is she still insisting? Oh, Saltgrass, is she still in? And it says in the stipulations that her mom is at a retirement community. And that people there became concerned. And that's when they discovered that the mom's credit cards were gone. And actually, the person who has guardianship of the mom became concerned as well.
Yes.
So it appears that your client was just spending money with no intention of paying it back because she didn't pay it back. Did she expect her mother, who's in a retirement home, to pay this back?
I can't answer that.
And it's like if she's saying that she had permission for it and it was a gift.
Not all of them. Not all of them.
Oh, you want to raise your right hand?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Can you tell you which ones?
No, you can lower your hand. State your name for the record.
Kimberly Mays.
All right, you can lower your hand. Your mom lives in a retirement community. So that I'm assuming that means that she's retired. Is that correct?
Yes.
And someone else has guardianship over her. Is that correct?
Yes, but I came back to her from the hospital. She had a heart attack.
No, my question is, does somebody else have guardianship over her?
I guess so.
And who would that be?
My brother.
I'm sorry?
My brother.
So when someone has guardianship over someone else, doesn't that mean that they're in charge of any type of spending of money? Correct?
Yes.
All right, so my understanding from reading the stipulations is you came to stay with her.
Yes. Yeah.
And you were staying with her, and then her credit cards were determined to be missing. And you didn't have permission from the guardian to take those credit cards, and you did. And were you going to Dobby's Nails, Specs Liquor Store?
Yes.
And were you going to Best Western?
Yes.
HEB?
Yes.
Torchy's?
That was with my mom.
All right. and Walmart and Dollar General.
It's pretty extensive.
All right. So,
Sorry.
oh, no, there's no need to apologize to the court. This is the state of Texas versus, so you can apologize to the state of Texas, maybe apologize to your mother, but my credit cards were not the credit cards that were taken. Do you have any questions of the witness state?
Ms. Essex. After having gone through that, do you believe that you were completely honest with the PSI officer?
Pretty much, yes.
Your mother gave you the card and that was that,
She, yeah, but not on all those charges.
but she gave you the card, but she gave you limited permission.
Yes, that's
And
correct.
you just took it too far.
A little bit.
You indicated to the PSI officer that you're a rule following person.
That was out of character,
What was that of character?
to use the car excessively.
I mean, you have more than a handful of other charges in here, several prison trips, were those out of character?
Several was.
Arrests and prison trips,
Yes.
are those also? At what point does it become your character?
I don't know. What was that? Oh, asking.
You told the PSI officer in
Yes.
this court that you're a rule following person, that this particular incident was
It's
out
just a
of
manic, yeah. A manic episode I have.
dating all the way back to 2007.
Well, 2007 is when I got a DWI.
Hurt somebody,
Yes,
right? You went to prison for that.
yes,
Was that out of character?
I guess so, yes. I'm right. I own it.
Picked up another DWI in Austin.
In
7 years.
2014, 10 years ago.
Was that out of
11
character?
I'm a little bit, yeah.
Done jail time for destroying somebody else's property?
That was my mom's house, but that's another story.
Was that out of character?
I don't believe that one was out of character. I had all my stuff in the house. I didn't have a way to get into any of my things.
And you kind of understand what I'm saying at?
Yeah.
You have a list of issues you've had with the law. So is it fair to say that this was out of character, or do you need help fixing your character?
I don't know what you want me to say. I really don't.
How many times have you been on probation?
I've been on parole.
Did they put you on probation in Travis County?
No, I did the county time and then I went to the prison for 29 days.
I'm gonna show you this, and it says that in August 2015, you're put on probation for 5 years.
Oh, okay.
And then
That's a PSI, right?
Well, that was probation, and then just under 4 years later, you were revoked, sentenced to TC. Were you not on probation in
Okay,
Travis
I thought
County?
it's PSI. Is that different or no?
PSI is something that happens post
Or before it
finding
gets
of guilt,
sentenced, right?
resentencing, yes. This looks like you're on supervision in Austin,
Okay,
the 3.5, almost 4 years, is that fair?
yes, that is correct.
What happened?
I would have told you, I mean, I remember being on PSI and then,
And I'm sorry, if you could speak this way.
it was a long time ago. I guess I was on pre-sentence, whatever it was, and then I ended up going to prison 2014.
And you had indicated, Ms. Essex, that you were not under the influence of any substances when this happened. This offense that we're here for, is that true?
I wasn't under the influence of when I charged this stuff.
Yes.
No, I mean, I had gone to the liquor store and whatnot, but I wasn't intoxicated. What is that?
No, I'll pass the witness, Judge.
Any questions?
Um,
Defense.
No questions, Your Honor. I do have a few things I'd like to address.
Yes.
While
Do
she
you have a
was,
trial court certification?
while she was in, Bear County, she wanted me to present those certificates to the court that showing that she is trying to be a better person. She's asking for, outpatient, intensive outpatient. She says she is willing to go to Laurel Ridge for an extended period of time. She has the threat of prison hanging over her head, which I think will motivate her strongly. To help her keep out of prison and be successful on this probation. She had troubles last time, but she is older. She is motivated.
All right, so, Ms. Essex, I want you to know that I heard everything that has been said. I've internalized everything. And this is what I want you to internalize, right? You've got to realize that the person that you committed this offense against was your mom. Your mom is in a retirement facility. Your mom is in such a state that she has a guardian, which legally means she's not able to take care of herself. And what you did, under the guise of, I want to be with my mom, I want to help my mom.
Yes.
You went into her retirement home, her apartment or community. And what you did was you took credit cards from a vulnerable person and you had no qualms about using those cards. And you would still be using those cards probably today, but not for the fact that the guardian of your mother said, hey, somebody's been using these credit cards. You had no intention for paying for that.
No, I would pay it back.
No, you say you would pay it back now, but that's because you have a criminal case. I don't think that you are a good candidate for probation. I'm not going to give you probation. I'm going to find you guilty. The enhancements are going to be true. The court is going to sentence you to the 10 years in the prison. You have credit for any time served. There's $1,000 fine. There's to be no contact with Dorothy Essex, Philip Essex. There's to be restitution, if any, to Dorothy Essex. I'll request a therapeutic community. There's to be no residing with any vulnerable person or anyone who's younger than 17 years of age or older than 65 years of age. The court, as previously stated, is giving you credit for any time served. Did you review the document entitled Trial Court Certification? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. And yes, your agreement was that either I would grant you probation or either I would sentence you to 10 years in the prison. And I'm sentencing you to 10 years in the prison. Good luck to you.
1 second.
Thank you. So who's ready?
For revocation.
All right.
Justin Gonzalez.
All right, Gonzalez.
Justin.
And it's a plea on 2 cases?
Yes.
All right, Ms. Abrams, this is a plea for 2 cases. Court is calling 2025 CR 011983, 2025 CR 008336, State versus Dustin Daniel Gonzalez. Can I have parties announced?
Lauren Espinoza for the state.
Greg Day Murray for Mr. Gonzalez.
And are you Mr. Gonzalez?
Yes, sir.
Counsel, in each of the cause numbers, have you received all discovery and that you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. In each cause number, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes.
And, oh, I'm sorry, just one moment. And cause number 2025 CR 011983. Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it and sign it?
Yes.
Did you understand you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to indict? And also, your attorney has certain rights. Your attorney has the right to have the passage of 2 days once he's presented with the information, and he has a right to have 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this, in each of these, in this case?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In that cause number ending in 83, did you review the information with your attorney? Did you understand it?
Yes, ma'am.
And did you review the true bill of indictment in the other case with your attorney, and did you understand it?
Yes, ma'am.
Do you waive the reading of both?
We do, Judge.
All right, off the record for a moment. One of these informations is supposed to be a copy for the defense. So does it?
Not there, Your Honor?
Well, I mean, there's two here. Do you have your copy, State?
I do. I gave defense counsel two.
Gave
but
me
I
both,
believe one
Judge.
should be-
We turned in the paper. I didn't know which one was the copy because it wasn't stamped, and I didn't want to take paperwork that you said. Or the court would
Obvious.
say, the district clerk would say, that's the original.
Okay,
Thank you, Judge.
you're welcome.
And I did go over this with my.
All right, thank you. And State, in each cause number, are you proceeding on the indictment and the information as presented?
Yes, Your Honor.
Mr. Gonzalez, in each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? In the cause number ending in 83, you're charged with collision and involving an injury. The range of punishment is up to 1 year in the Bexar County Jail and not more than 5 years in the prison, and a possible fine of $5,000. And the cause number in 36, you're charged with driving while intoxicated third or more. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In each cause number, if you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering into these plea bargain agreements, you are giving up those rights. Did you intend to give up those rights and enter into pleas in each of these cause numbers?
Yes, ma'am.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was, Judge.
Sir, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering into these plea bargain agreements, you can be deported, denied naturalization, and re-entry into the United States. Did you understand?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
Right. In the cause number ending in 83, according to your plea, punishment is to be assessed at 5 years in the prison. There's a $1,000 fine. There is no application for deferred adjudication, and if there is, the state opposes it. The state recommends community supervision. This is run concurrent with 2025 CR 008336, and there's to be restitution to Gary, is this? Nell, Nel. And in the cause number ending in 36, according to the plea, punishment is to be assessed at 10 years in the prison. There's a $1,000 fine. The state is opposed to, well, there are no applications for deferred adjudication, but if you were to apply for deferred, the state is opposed to it. State does recommend community supervision. This is to run concurrently with 2025 CR 011983. There's to be restitution The restitution of the 13,000, who is that to?
That's to the city of San Antonio, Your Honor. There was a rear end accident of a patrol unit caused by the.
All right, there's to be restitution of $13,112.90 to the city of San Antonio, $60 to DPS, and restitution, if any, to Gary Nell. Did you understand that to be the plea bargain agreement in each of the cause numbers? Defense is at the plea?
It is, Judge.
State is at the plea.
Yes, Your Honor.
In each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Outside the agreement, I'm sorry, counsel, have there been any such motions?
No.
Outside the agreement, in each cause number, the state is recommending that your community supervision be for a term of 10 years. There'll be a TAP evaluation, 200 hours community service restitution. And the charge of the DWI third or more, they're asking for ignition interlock for half the term, DWI intervention BIP live. And also, there's a requirement of 10 days in the Bexar County Jail as a condition.
Your Honor, he's actually been in jail prior on this case, I think for almost 30 days. I can get the exact number. It was over 10.
Okay, I usually don't do credit that way. But do you understand that those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
And do you understand with the DWI third, the court can sentence you up to 10 days, where there is a 10-day sentence as a condition of your probation?
Yes, ma'am.
Okay. Then in cause number 2025 CR 011983, how do you plead? Guilty, not guilty, or no contest? And in cause number 2025 CR 008336, how do you plead?
No contest.
State in those cause numbers, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 and all attachments in both.
No objection, Your Honor.
All right. And state, have you spoken with the complainant?
Yes, Your Honor.
All right. And each cause number, did you review the stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
In each cause number, the court will find there's sufficient, in each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. And in each cause number, the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, what can I say? My client is here before you. He takes responsibility. He's angry. And as he's been in here and he knows how you work, he understands the gravity of the situation. He understands what's ahead of him. Just ask that you follow the plea bargain.
All right, here's my question with regards to the amount that's owed. Has he paid that? Has insurance paid that?
Your Honor, I don't believe insurance is going to pay that. It's a claim that was filed. It was not his car. It was another person's car. And because he was not on that insurance, he does have gainful employment, Your Honor. He does work. So that's something that he will definitely.
So when is the 13,000 going to be paid?
Your Honor, probably. He's asking within a year, Your Honor, making payments.
All right, when will you be able to at least pay 3,000?
Maybe about 2 months.
All right, this is what the court is going to do. Since both parties have agreed for probation, I'm going to ask that there be the TAP evaluation done. Obviously, there are some drug issues going on here. And when I say drugs, I mean alcohol. It is a drug depending on how you use it.
Yes, ma'am.
Ms. Abrams, how long would it take to do a TAP evaluation?
Standard, as we get 4 to 5 weeks.
All right. We're going to come back in 30 days, and at that time, the court will give sentence, and you need to make sure that you come back with some money towards restitution. And I believe that we can go off the record. I believe that can be done in the form of a money order or a cashier's check, but not cash, okay?
Yes.
All right, Norm, I need a 30-day reset for sentencing. October when? All right, so we'll be back on October 30th. And Ms. Abrams, it's just for a TAP evaluation. And counsel, I know you teach. Is that a good time?
Perfect.
All right, and then counsel, if you want to appear by Zoom, you can appear by Zoom.
Thank you, Judge.
All right.
October 31st, we're supposed to have a candy salad, so just can't do it.
Okay. Have a good one.
All right, thank you. Judge.
All right,
Thank you,
and
Judge.
Ms. Abrams. He has Colorado connections.
Oh.
You're welcome. All right, court is calling 2023 CR 7445 State versus Troy Daniel Harris. Can I have parties announced?
Rick Pena for the state of Texas.
For you, Scott, so.
And are you Mr. Harris?
Ma'am.
And is the date on the motion to revoke, is that from June 2025?
Correct. Yes, Your Honor.
All right, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Troy Daniel Harris who's placed on deferred adjudication in 2023 CR 7445 for the offense of indecency child exposure on February 12th, 2024 for a period of 10 years? Is that you?
Yes, Your Honor.
All right. State.
Violation of condition number 23I on or about the 24th day of May 2025 in Bexar County, Texas. The defendant, Troy Daniel Harris, who then and there failed to comply with the instructions of the Bexar County Community Supervision and Corrections Department Sex Offender Program, and that the defendant possessed and viewed video on his wireless phone, material that is sexually oriented and or portrayed the nudity of an adult in violation of condition number 23I.
How do you plead to that? True or not true?
True. State will waive the remaining violations, Your Honor.
Any objection?
Okay.
Did you understand by pleading true to 23I, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to 23I?
I do.
Court will find 23I true. Is there a proposed agreement?
Sure, that is to revoke the defendant's probation, adjudicate him guilty, and sentence the defendant to 6 years TDC.
That's great.
Are you asking the court to follow that agreement?
I am.
Are you waiving your right to appeal? All right, the court will follow your agreement, find you guilty, revoke, sentence you to 6 years in the prison, give you credit for any time served. Oh, thank you. No problem. There's to be continued Chapter 62 registration and no contact with the complainant. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. When you are charged with certain cases, even when you're on probation, even when it's involving adults, you're not allowed to view it, and you're not allowed to have computers without first clearing it with your probation. Do you understand? All right, good luck. Thank you. You're welcome. All right, and if you'll come forward, where are we on discovery?
Judge, I was supposed to bring him a disc. And I totally forgot it was set for today, but after that, I'll have all the evidence here.
All right, Ms. Ferguson. Yes. If you can recall this for 30 days and state you'll need to be prepared to tender an offer.
Yes, Judge.
All right, so we'll be back on October 30th. Thank you for dressing appropriate for court. Just have a seat. And once you sign the reset form, you'll be excused.
Thank you, Judge.
Thank you. Willie Contreras.
Yes.
If you'll come forward.
Yes.
All right, your attorney sent an email to us that they were starting jury trial and then you were gone. Otherwise, you could have been finished.
Yes, ma'am.
All right, Ms. Ferguson. Recall this. Let me see, where are they? Recall this in 2 weeks.
Yes.
All right, so we're gonna recall you. And is that a Monday?
Yes.
All right, so we're gonna recall you. Oh, I'm so sorry, Norman, not in 2 weeks. They say that they expect the trial to be concluded this week. So can you recall it that first Monday? All right, so we're gonna bring you back on October 6th.
Yes, ma'am.
So just make sure you're here. If for some reason your attorney's still in jury trial, they'll email us and let us know.
Yes, ma'am.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately.
Yes, ma'am. Thank you, Your Honor.
You're welcome. No, we'll take up Havana Miller. And is your client here in the courtroom? All right, if you'll take a seat here. And state, are you prepared to proceed? All right, the court is going to call 2025 CR 001454, State versus Dejanay Havana Miller. Is that correct? Or is it Miller Havana?
Havana Miller.
All right. Could I have parties announced for the record
Open for the state.
and for the defense?
Jared Hall and Jody Sawyers for Havana Miller.
And are you Havana Miller?
Yes.
All right, we are back on the record. And who is the expert or the information you're seeking for clarification defense? Who is the expert?
It's Dr. Godbetter, Your Honor.
All right. Could Dr. Godbetter, if you could show video, please.
Yes, hi, Judge. I have the video on. Just not sure why it's not showing.
All right, just give me a moment. Do you want to try to zoom out and zoom back in?
Yes, we'll do.
Okay. So the court is in receipt of the two motions related to this hearing by the defense. State, have you had a chance to review those motions? And are both parties ready to proceed on this motion? All right, and Ms. Miller, I just have a question to ask you regarding this witness appearing by Zoom. Can you raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. All right, so this hearing is taking place with the witness by Zoom. You have a right to have that person appear in person in court. Do you have any objection to the witness appearing by Zoom? All right, defense, any objection to the witness appearing by Zoom?
Not for purposes of hearing.
All right, and state, any objection to the witness appearing by Zoom? All right, call the witness.
We'll call Dr. Godbetter.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. And everyone, if you could make sure that you speak into the microphones that are on the table so that the witness can hear by Zoom. The microphones attached to your lapels, those are for the court reporter to be able to hear. And Dr. Godbetter, if at any time you cannot hear, just let us know.
Okay.
All right, if you will state your name and spell it for the record, please.
Yes, my name is Marilyn Godbetter. That is Marilyn. Gotbeter.
All right, defense, you may proceed.
Thank you, Judge. And may I remain seated just so that.
Yes.
Thank you. Good afternoon, Doctor. Can you hear me okay?
It's a little far away, but I may ask you to repeat it if I don't hear you.
Not a problem at all. Is this any better?
It's still a little far away, but I will do my best.
Okay, I'll speak up. All right, so can you tell the court what licenses you hold?
I'm sorry, I didn't hear that.
Can you tell the court what licenses you hold?
Yes, I have a veterinary license, so I do have, I graduated from veterinary school, so I am a licensed veterinarian in the state of Texas.
When did you graduate?
It was in 2009.
All right, and where'd you go to school?
Cornell University.
Okay. And how many years does it take to get the license that you have?
Pretty much a full 8 years. So the full undergraduate degree and then the professional graduate degree.
All right. And tell me a little bit about your current practice. You work with ACS, correct?
Yes, I am currently the chief veterinarian for Animal Care Services.
And tell me a little bit about what your day-to-day looks like.
So we take care of the city of San Antonio's population of stray pets. And so we will see injured animals. We will see healthy animals as well. We do cruelty cases. We do confiscate cases, large scale impoundments. We will see livestock and exotics and pocket pets, depending on the need. And that is for the city of San Antonio.
All right. And for you personally, what steps of the process are you involved in?
In regards to the animals that are coming to the shelter, my responsibilities include performing examinations, creating treatment plans, ensuring that the health and well-being of the shelter population is in alignment.
All right. And when you say examinations of the animal, you mean primarily physical examinations, correct?
Yes.
All right. Okay. So you graduated in 2009. What kind of, do you have any kind of specialized training since 2009 in this field?
Yes, so throughout the course of my career, we are to have continuing education requirements by the state board. And then in addition, we do training regarding our own specialties. So for example, for shelter medicine, going along with training on what is seen here at the shelter. So training on necropsies, cruelty cases, confiscates, population medicine, public health. That's just to name a few.
Okay. And tell me a little bit specific courses that you've taken in your field that you can recall.
Specific courses, a lot of them have to, the ones that come to mind are conferences that go over specifically with shelter medicine. So conferences such as Best Friends Conference, Humane Society of the United States conferences, other conferences such as for medical needs would be IVEX, ABVP. Definitely they have shelter medicine tracks, which include identifying different aspects of what is needed to be performed as far as the job duties for shelter medicine.
All right. And can you just briefly tell me a little bit about what shelter medicine is?
Shelter medicine is a specific focus in veterinary medicine that involves not only population medicine, but individualized medicine. So population medicine is ensuring that we are preventing disease spread in a shelter environment, ensuring that husbandry practices are in alignment with the Association of Shelter Veterinarians and the standards of care in shelters. And then individualized medicine includes triage, stabilization of critical patients, and then as well as performing examinations for animals, for example, that are part of our different placement programs. And then there is the aspect of cruelty and confiscate. So cruelty examinations, necropsy, performing necropsies, and cruelty necropsies, as well as assisting with large scale impoundments and how to navigate through those different types of cases. Such as like hoarding cases, pit bull fighting, cockfighting, so just a milieu of cases.
All right. And have you testified before on these subjects?
Yes, I have.
All right. And do you have any board certifications under your license?
So I do not have like a specialty board certification, for example, as far as like being board certified in, orthopedics or anything like that. No, I do not.
All right. Do you have any publications in the field?
Only one publication that was for Addison's disease, and that was during my time in veterinary school.
All right. So that was before you were licensed, right?
That was part of the licensing part of it, but yes.
Okay. All right. And let's talk a little bit specifically about behavioral science. In the last 5 years, have you had any kind of education on behavioral science?
Yes, and behavioral training. So there is a veterinary behavioral training that is not only part of our curriculum in veterinary school, but it is something that, as part of shelter medicine and understanding, cruelty cases, that is one of those components that we do receive in the shelter medicine track. Yes.
All right. And tell me a little bit, when you receive an animal at the shelter, what's your typical method of examining that animal?
The first step is the history. Veterinarians require the history in order for them to have a little bit of a background. If there is no history, they are still able to perform their physical examination. And then after that, they move forward with the physical examination, and then they create their assessments and then their plan on what their treatment, they believe the treatment needs to be.
All right. And that physical exam is very important, right?
That is the component of the assessment for the animal, yes.
All right. And why specifically is that part of the examination important?
So it's examining the actual patient.
All right. And from the physical examination, the next step then is to, of course, as you testified, provide your assessment, right?
Correct.
All right. Or a treatment plan, rather, right?
Yes, or recommendations that are needed for the pet.
Okay. All right. So as far as your physical examination, obviously when we're looking at an animal's mental state, it's different than, for example, examining a human, right?
I can only speak to animals.
Right. But of course, animals can't speak to you or report issues, correct?
So veterinarians, yes, animals are nonverbal. So we do have to assess the animal with nonverbal cues.
Okay, so if you were to make an assessment based on that, it would require some degree of speculation, right? Because the animal can't talk to you.
No, not necessarily. The idea behind our assessments should not be based off, we have our rule outs, but not necessarily speculation. It's more of what our rule outs are. So what we suspect would be the issues. But they're with behavior with animals. For the most part, there are telltale signs for certain behavior aspects, and there's reasons why animals will show certain behaviors. And so it's more of using our training to be able to identify what may be going on.
All right. And are there specific mental examinations that you can administer to animals?
Did you say mental
Correct.
examinations?
Yes, ma'am.
We typically do behavioral examinations.
Okay. And tell me a little bit specifically about the behavioral examination. How do you go about that? What are the steps to that?
Sure. So any examination that is performed on an animal, you have to assess their behavior. Number one, for safety purposes. Number two, it's also for the comfort of the animal. And reading the behavior, the animal can actually communicate a lot non-verbally. It's a matter of picking up on those cues and paying attention to the nonverbal language of the animal prior to going ahead and performing the actual physical exam.
All right, so you do it before the physical examination, correct?
You can do it before and during as well.
What's your preference?
It's more of the before is assessing the animal for, again, it goes back to safety, ensuring that the animal is comfortable, ensuring that the environment around the animal is the best that it could be for you to perform a physical examination that is going to be safe for the pet. And then during the examination, the animal may provide, behavioral cues that will let you know whether the animal will basically communicate things to you as you're performing that examination.
All right. Okay, and you mentioned nonverbal cues. What nonverbal cues do you look for when you're examining an animal?
Sure. So nonverbal cues, first is the body language of the animal. Are they comfortable? Are they fearful? Are they more engaged? Do they want to be approached? Do they not want to be approached? Are they approaching themselves? Are they acting aggressive? So those are some of the examples.
All right, and tell me a little bit, what role, of course, the animals, when they come to the shelter, they're being brought to a new environment, right?
That is correct.
Okay, and they're transported by people that are unfamiliar to them, right?
Yes.
Okay, all right. So how do you distinguish, are there ever problems distinguishing between, hey, this is a nonverbal cue from, being placed here in this unfamiliar environment versus, hey, this is a nonverbal cue that indicates something else. Have you had that issue before?
So animals will demonstrate that, and that is the whole purpose of identifying how initially they are behaving so that you can make them as comfortable as possible. And they will continue to communicate to you non-verbally. Then at that point, you can identify whether or not this is something, like if they had prior imprinting, so prior behaviors that is part of their behavior, or if this is environmental induced.
All right. Let's talk a little bit about this case. You performed an examination in this case, correct?
Yes.
All right. Do you remember what date that was?
The examination on the January the 21st.
All right. And did you do a report based on that examination?
Yes.
What date did the dog come into your custody or ACS's custody?
That I don't know if I have that information. I will have to check.
All right. Would it surprise you if it was?
That was the 17th, January 17th.
Okay, so there was a period of delay between the time that the dog got into ACS custody from the time till the time that you were able to look at it, right?
Yes, there were days in between, yes.
All right, and what was the cause of that delay?
I do not know I don't know if it's necessarily considered a delay. I don't know the cause. I can tell you that I was able to examine the pet on the 21st when I was notified of the case.
Okay. All right. So you weren't notified until January 21st. You performed your examination. Would you agree with me that, that 4-day block, findings could be different if it were done, for example, on the 17th versus the 21st? Would you agree with me?
It depends on the case. It depends on the case. I'm and specifically what I'm not sure what you mean by findings. So it depends on the case. Certain cases, things, certain medical cases, for example, things will change with time, and other cases they do not change, and you can still do your assessment even if it's not on the same day that they were brought in.
What are some things that change with time?
So for example, like wounds, so if there's open wounds or infections, those things can change with time. Other types of injuries or scars, those do not go away, so they're not necessarily time dependent. So again, certain parts of the physical exam are time dependent and other parts are not time dependent.
Okay. You said that wounds could be time dependent. Are there any other injuries that could be time dependent, such as trauma? Is trauma time dependent?
It depends on the type of trauma. Certain traumas are not time dependent and other traumas are.
What types of trauma are time dependent?
So if it's again, if it's something that is a little bit more subtle, it could be time dependent if it already heals on its own, and then other things are not. For example, like behavioral things are not going to be time dependent. So for example, we can have cases, we can have like bestiality cases and that have endured that trauma 6 months prior, and their behavior does not go away. And so that's not necessarily time dependent.
Okay. And when you refer to the subtle trauma that might be time dependent, is that physical trauma or mental trauma or a combination of both?
I think it's a little bit, again, probably the physical trauma was what I was talking about. Behavioral trauma, those when animals become imprinted, those are not necessarily something that fades away.
Okay. And if you can give me an example as to trauma that would not be, what would trauma be that would be considered subtle, in your opinion?
I'm sorry, I don't understand the question.
Let me try to clarify it a little bit. You referred to subtle trauma that might be time sensitive or time dependent versus, long-standing trauma where an animal is examined 6 months after, the trauma has occurred. What are some other types of acute or subtle trauma that you see in your day-to-day?
Yeah, so like for example, like some scratches or some scrapes, those things can they can heal fairly quickly, especially if it's some type of blunt force trauma. Sometimes even on the day of blunt force trauma, you don't necessarily see it. So you won't necessarily see the bruising. It just depends on the level of the trauma.
Okay, what about spinal injury or trauma?
If it is spinal injury, that will not go away with time. If it is for example, like a broken back, that is something that is not going to go away with time because the injury was so aggressive that it would remain there. So if you have, for example, a broken back, that's something that's just not going to go away with time. You'll be able to see that.
Okay. Tell me a little bit about fear imprinting. What is that? Can you explain that?
Yeah. So fear imprinting is essentially a behavior that an animal will, it's an experience that an animal undergoes that creates a fearful response. And so they will have a learned behavior to have that type of fear.
Is observing or, treating or assessing fear imprinting, is that time sensitive?
As far as to identify it,
Yes, ma'am.
no, not necessarily.
Okay, and why is that?
So imprinting on a pet, the experiences of the pet is once they develop that imprinting, it's something that doesn't necessarily go away. And they may, so for example, if you put them in a situation where they should not have that type of response and they do, and it's an inappropriate response as compared to your general response that you would expect, then it would be considered that they have been imprinted.
Okay. And regarding the dog, in this case, or sorry, let me back up one more question as to fear imprinting. What can cause fear imprinting?
So it's many things can cause fear imprinting. It could be any type of a trauma that the animal can go through. For example, if they're not provided the appropriate husbandry resources, or they are in they are being exposed to kind of a repetitive treatment, then over time they will develop that imprinting.
Okay. And how can you rule out other potential causes or factors that could show some of the behavior that you're seeing?
Sure. So that is part of the assessment when you're doing the physical examination, is to ensure that the environment around the pet is not causing that type of response.
Okay. I think you may have misunderstood my question. My question was how other potential causes, based on the animal's history or anything else, how do you rule those things out? Is there a specific method that you use to rule those things out?
What causes are you referring to?
Anything else that could be bad behavior or, submissiveness, anything else that might cause you to, find fear imprinting, other potential causes, how do you rule them out?
It's usually when you provide that type of stimulus to the pet and the pet does not respond the way the appropriate response.
And how do you determine what's an appropriate response?
So for example, if your body language has been tailored to the pet and you're not doing anything that is threatening, and then the patient provides an overreaction to even a behavior that didn't even require a reaction to, and then you can identify that is an inappropriate response to the stimulus.
But can you just clarify, how do you determine, in your position, when an animal gets you, how do you determine what specifically caused the fear imprinting? Is there a way you can do that, or is that unclear?
So are you saying that if an animal was identified, it may have some fear imprinting, and we want to identify what the cause of it, what caused the fear imprinting?
Yes, ma'am.
Again, that goes, if there is a history that is provided for the veterinarian that allows to, okay, these are the potential sources, then that would be something that they could identify. These are the causes, or the potential causes. If there is no history provided, then we can suspect based off of what their behavior is and only provide potentials basically of, for example, if you have one dog that is dog aggressive, every time another pet walks by, the dog is very worked up about the animal that's passing it by, but there's no other history, we can provide potentials. They could either be resource guarding, they could be behaving this way because they are behind the kennel. Again, another resource guarding type of behavior. They may not necessarily be aggressive to dogs once out of the kennel. And so you can only provide your, best potentials of what that behavior is being caused by, but we wouldn't be able to say it was due to a prior experience or whatnot.
Okay, so there's no sure. I'm sorry.
And then there's cases where when you do a certain behavior and the animal responds to it in a negative fashion, but that is an over response or it is not in alignment with what, a pet that hasn't had that type of trauma before, then yes, you can make suspicions of this may be an animal that has been abused before.
All right. And so what you're saying, as far as, you're looking at different potentials and what you suspect might be the cause. There's no surefire way to say this specific action caused the fear imprinting in the animal, correct?
There is, if there is history. If there is a history and it's documented, this is what happened to the pet, then it is fairly straightforward. There is. And then if you have other cases where you don't have that history, then it's you have your best rule outs of what it could be. And but at the end of the day, it's important to understand that the animal still carries that fear imprinting, and you need to tailor your behavior at that point so that it doesn't make the animal uncomfortable or have a fearful response when it's not needed.
Okay, so if you're provided adequate history, and other factors regarding the history of the animal, you can be able to, or might be able to, specifically say this was the cause of the fear imprinting, right?
And sometimes if it's not even exact history, we're able to say, yes, this is what happened. So we can tell that this is. So for example, a pet can come in with an injury and we are told one story of how the animal got injured. However, the way the injury is and the way the animal is behaving, we can tell that this was a human to animal trauma. So there are certain things that, despite even the history, based off of how the animal is behaving, based off of the findings that we have, it's clearly that there was a human to animal trauma.
Right. All right. So did you review history in this case?
Yes, I did receive history. Yes.
All right. And one or more incidents.
I'm sorry?
One or more incidents regarding what you reviewed.
I do not recall if it was more incidences. I do recall the report of the incident that was provided to me.
Okay. All right. And as far as, did you review any medical history for the dog?
To my knowledge, I don't recall, but I don't believe I had any other medical history, but I do not recall at this time.
And are you aware that an initial examination was done of this animal?
My understanding was that this pet was taken to our contract clinic when it was impounded.
All right. And did you review that report?
I do not have those records. That would be the cruelty team that has that.
And that report was done shortly after. Would it surprise you if that report, the assessment was that the dog appeared healthy?
Again, I wouldn't be able to speculate. I would have to see the report and read the veterinarian's notes.
All right. Okay, so you didn't have, the only thing you reviewed was regarding one incident, no medical history. You did a physical examination in this case, correct?
Yes.
All right. And how long did that take?
As what is needed for the physical examination. So, after essentially after being provided the history, the understanding that the animal was seen at the ER, the animal did receive pain medication at that point. I did my physical exam, and assessed whatever else it needed.
So you knew that the animal was to receive pain medicine. How did you know that if you hadn't reviewed the prior report?
So that is something that was provided in the history. So I was aware that the animal was taken for the ER exam. I don't have the vet's notes directly in front of me in order for me to testify on that veterinarian's notes. But that is, again, part of the history that I was provided.
Okay. But you didn't include that here in your history section of the report that you wrote, right?
As far as the what did I not include?
That you had reviewed the intake or the other history based on this animal.
Everything that is in my notes is complete. So so the history of what was provided regarding the pet's owner and was included, and the video as well that was provided, and then the information that the pet was at the ER, received the pain medication, and then the remainder of my physical examination.
All right. So you didn't include anything in your report then where the dog was found to appear healthy just 4 days before that. You didn't include that because you weren't aware of it, right?
No, I didn't include that because that is the other veterinarian's physical examination findings. And so what I had included is my physical examination findings, and then, of course, the history that was provided.
All right. Let's talk a little bit about well, let me back up. Would that information have been helpful at all to you in making your treatment plan or assessment?
I mean, the information was provided, the history was provided. So it wasn't anything that was missing.
Okay. All right. Yeah. Okay. So let's go down to your physical examination. You state, of course, again, that the dog received pain medication. What medication was that? Do you recall?
I would have to have the veterinarian's notes in front of me for me to be able to answer that question.
Okay. And are those notes that you took?
Which notes?
Well, you state that the dog received pain medication, so you're not aware what medication that was, what dosage, anything, right?
That is so yes, I did include that the pet received pain medication. Those medications are going to be part of the veterinarian that examined the pet. That's in their notes. So that is not something, again, each veterinarian is going to put their history, they're going to put their physical exam findings, and then their treatments. It's not necessarily we are going to be including another veterinarian's notes into your new physical exam notes, if that makes any sense. So
Okay.
that information is in the other veterinarian's notes.
All right. Okay. So let's go down to the second line. well, just based on your recollection, you reported that the puppy was BAR. That means bright, alert, and responsive, right?
BAR is bright, alert, and responsive.
Okay. And what actions or behaviors did you observe that led you to report that?
So they have to, so bright, alert, and responses, there's different levels of assessment. So when they're essentially what it states, bright, alert, and responsive.
All right. And you also reported that the dog was playful and ambulatory, right?
Yes.
Okay. So as far as you reported that the dog was sensitive to loud voices, is that more typical or less typical in animals that are younger?
Neither. Again, it's more of that pet's response to certain stimuli and how they would behave. So this pet was already bright, alert, responsive, active, playful, and ambulatory. So that demonstrates that this pet was already comfortable within its environment to be able to be playful and ambulatory. And when there were some loud voices, so essentially the staff member and I talking and speaking, the pet would retract in a submissive position, which is an inappropriate response for that pet, given that it already started off in a comfortable setting and was demonstrating that it was comfortable.
Okay, you said that was an appropriate response, right?
Inappropriate.
Inappropriate response. Okay. All right. So did you perform any specific testing regarding that specific issue regarding the dog being sensitive to loud voices?
It didn't even need specific testing, so very basic human voices, and the puppy was having an inappropriate response to it.
All right. And what happened? I mean, what loud voice was it? Your voice that the dog heard that caused the response that you're referring to?
No, it was just more of us talking and having our normal loud voices, and the puppy was having inappropriate response to it.
All right. You also report that the dog froze upon examination and handling. Had you ever met this dog before January 21st?
No.
All right. So you were a stranger to this dog, right?
Yes.
All right. And the people there, at max, they had only seen this dog for 4 days, right?
I'm not sure which people, but for myself, I had met that puppy on that date.
Okay. And is that typical or is that rare for animals to be, to freeze or be afraid of somebody that they've never seen before, especially young animals? Is that common?
Depends. Again, that's the whole purpose of the steps that you take when you're introducing yourself to the animal. So you don't just go straight and grab onto the animal to be able to do an exam. You have to introduce yourself to the animal. You have to go ahead and, handle the animal, and then you can go ahead and do your physical exam. So it really just depends.
All right. How do you introduce yourself to the animal to be able to perform the examination?
Sure. So first step is obviously there's an eye contact, but you don't want to make direct eye contact depending on what their behavior is. You do need to adjust your own body language so that you don't come across as threatening. And again, it's just dependent on you reading the nonverbal cues of the animal. If the animal's demonstrating some fear, then you need to adjust your behavior so that you can make that animal more comfortable. And then you introduce yourself to the animal. So you go ahead and you provide your hand in a certain manner. There's different hand gestures that you can do. Some hand gestures are a little bit more threatening than others. And so you really have to read the behavior of the animal to be able to assess what to provide to that animal to make them feel comfortable.
All right. And you observe this response, which you considered to be an inappropriate response, what other causes did you rule out for that behavior or response?
What other causes are you referring to?
Did you rule out any other causes for that behavior, or did you just, go straight to that specific cause that you assessed? Did you rule anything else out for that behavior?
So the behavior is what the puppy is demonstrating. I don't know if it's something that you need to rule out. It's essentially what occurred with the puppy. So the puppy will freeze when you're handling and evaluating. So this is again with just the very, the initial steps that you take, and then understanding the puppy's behavior to begin with and its comfort level within the environment, and then moving towards your physical examination.
So you didn't identify the cause of the response to those stimuli, right?
I guess I don't understand with a cause. Again, it's the puppy's behavior was just reported. This is the behavior of the puppy upon handling and evaluation.
And what were your findings as a result of the response that you observed?
In regards to the behavior?
Your assessment, rather. Yes, ma'am.
So with the behavior, the puppy was comfortable in the environment. We introduced ourselves. It was definitely our ability to make the puppy feel safe, that we can go ahead and perform an examination. And we chose an area where it, was a non-threatening area, not necessarily like in an exam room with other pets that are there. So that way it is as comfortable as possible for the puppy. And then the assessment for the behavioral wise was the puppy was sensitive to the loud voices, did retract into submissive position. And then with just the handling and the evaluation, the puppy did essentially just freeze, would not move at all.
All right. So what was your assessment? Specifically, what was your assessment based on that?
So in totality, with the full physical exam and looking at the video and taking into consideration the history, that there, based off of the video, there was blunt force trauma that the puppy did endure, and that's essentially the assessment.
All right, let's talk about that a little bit. Your next finding was as to the dog's teeth, right? Or the next thing that you reported on your physical examination, you took a look at the dog's teeth, right?
Yes, the oral exam is one of the parts of the examination, yes.
Okay, did you observe any damage to the dog's teeth or mouth?
There wasn't. What was observed was the incisors, the baby incisors, they're called deciduous incisors, were absent.
Okay, and what, are you aware of why that was the case?
So we assess, we do an oral exam to look for any trauma, but we also do an oral exam to properly age them, and to give a good guesstimate of what the age would be. So that is in alignment with the age that was approximated.
Okay, so in your physical examination, you didn't observe any trauma to the teeth or the mouth?
No.
All right. Did you, in your physical examination, did you look at all of the dog? Did you look at the dog's whole body?
Yes. Okay.
All right. Any injuries that you observed in your physical examination to the dog's eyes or ears?
It was, the main findings were again the age of the pet on the oral exam, and then there was some waxy debris for both ears, and then there was some redness that was noted on the left side of the pelvic area.
Okay, and you noted mild waxy debris, AU. That means on both sides, right?
Both ears, correct.
Okay, and that indicates that it's not something, trauma or injury related if it's on both ears typically, right?
It's just more of this is a finding that we would see with the breed.
Okay, so it's not related to trauma specifically.
No.
Okay, all right. As far as going back to my original question, did you observe any injuries? Did you take a look at the dog's nose?
Yes, the full physical exam is from nose to tail. The findings are what gets reported as far as if there's any main findings that need to be focused on.
Okay. And in your physical examination, in that section of your report, the only physical injury that you report to the animal is the mild arrhythmia noted along the caudal left pelvic region, right? That's the
Yes.
only part of, okay. All right.
And the inappropriate response with the behavior.
But as far as physical injury to the animal, that's in your physical examination section. That was the only physical injury that you observed to the animal.
Yes.
Okay. All right. And what exactly is arrhythmia? Sorry, you can pronounce it. What is
sure.
that?
Erythema is just redness. So it's basically on the skin. So it's redness of the skin.
And what can cause that?
So that could be from trauma. Typically you're not supposed to see erythema. So that is going to be something that would induce that redness on the skin because the skin is not supposed to be normally having a patch like that unless there is some type of insult that's there.
Sorry to interrupt. If you could spell that for the court reporter, please.
Erythema.
All right, you may continue.
Thank you, Judge. Okay, all right. And you said that it could be trauma. What other causes could cause arrhythmia? You can say it.
It's usually anything that would traumatize the skin would cause the redness. There's other things. So for example, if they already have, if they have a skin infection. So again, it's just demonstrating that there is compromise to the skin.
What about scratching? Can that cause that form of redness?
It depends. So you should be able to see the actual scratches. And typically it's not something that should stay there for too long unless they are constantly scratching.
Okay, it shouldn't stay there too long. What about gnawing? I know some dogs gnaw when they get anxious, or can that be a cause of that redness?
So there would be other findings, for example, broken fur shafts, some abrasions, some excoriations from the teeth. So again, you see that, and if it was from gnawing, then it would be something that you would be able to see the dried saliva that's on the fur. You would be able to see some of the fur shafts that are broken, and that was not notated.
So as far as scratches, let's back up to that a little bit. You said that the scratches don't stay there too long, right? Is that what you testified to?
Yes.
Okay. So how long is too long? How long can they stay?
I mean, it depends on the severity of the scratch, but if we're talking about a superficial scratch, those are sometimes even hard to see. So
okay, so it's possible then that in the 4-day gap from the time that the dog got into ACS custody to the time that you took a look at the animal, it's possible that scratches wouldn't have been there after the 4 days. Is that possible?
So I mean, the insult should equate to the injury. So if there were scratches and then it was superficial and it didn't last that long, everything else should also go away. Typically, erythema is a little bit more of you affected the skin to where it is red, and it's more than just the top part of the skin.
All right. Are you able to rule out that it was anything that could have happened in the 4 days while the animal was in ACS custody?
Like speculate on if something else could have happened?
Are you able to rule that out definitively?
If it was not provided, I don't know. Again, that would be speculating, if something were to have happened. Again, the findings are that there was redness identified on the skin on the left side of the pelvis.
Okay, so you're not trying to say what caused the redness, you're just trying to say that the redness was there, right?
That is present, correct.
Okay, all right, sounds good. Okay, all right, and you looked at the whole dog, you said that the only physical injury you saw to the dog was that redness. Did you observe any blood or any other kind of, anything like that on the dog?
No.
Okay. Can going back a little bit to the redness. Well, actually, let's move on a little bit. You say that was on the pelvic region. What part? I understand where the pelvic region was, but was that on the outside or the inside of the animal, like the underside or the top side?
On the top side, on the
Okay.
left side.
On the left side, okay. All right. So you did your physical examination. You saw the redness on the pelvic region, but then, despite there being no other injury, you found that there was blunt force, or assessed that there was blunt force trauma, right?
Yeah, so blunt force trauma is something where you don't need to necessarily see blood or broken bones or severe wounds. Blunt force trauma comes in many different forms. So hitting can cause blunt force trauma, and it can cause internal organ injury, but not necessarily something that you see on the outside. It can cause some spinal shock, but it doesn't necessarily demonstrate on the outside. So blunt force trauma was reported as the assessment given the history of the pet and what was reported as far as the video and what was seen in the video, as well as the physical examination findings of the behavioral aspect of it.
Okay, the behavioral part, but you're finding a blunt force trauma doesn't come from any injury that you located in your physical examination. Nothing in your examination specifically indicated that, just as to the history.
The examination is it does include behavior. So behavior is not a separate aspect of the examination. So the examination is both looking at the animal nose to tail and then the behavioral part of the animal. There was redness that was noted on the left side, which again is the redness that has just been noted on the skin of the left side of the pelvic area. But in combination with the history and the physical exam findings, which does include the behavioral aspect, this is a case of blunt force trauma.
Okay, so you made this finding without any specific physical injury showing up in your physical examination. It was all behavioral, essentially, right?
No, blunt force trauma does not require an actual evidence of a broken bone or an open wound or blood. So it is the totality of the case with the history, the behavioral, and the physical exam that will provide the assessment of this animal endured blunt force trauma.
And what was the object that caused the blunt force trauma?
I cannot tell you 100% what the object was. Based off of the video and what had been reported, but I did not have the exact object.
Do you have a guess? What do you think it was?
Again, I don't think it would be appropriate for me to speculate, so I wouldn't be able to tell you. I can tell you what the behavior was on the actual video, but I wouldn't be able to speculate.
Did it look to be a flaccid leash? Like a dog?
So from what was reported to me of what they suspected that it could be, it was of a leash-like flexibility. But again, we don't know what the actual object was.
All right. So, as to your next assessment, you ruled out neglective care. Let's take a look at, you found that there was head trauma, but again, you didn't find any injury to that area in your physical examination. Any physical.
Did not find head trauma, put as a rule out the head trauma. So consistent with what was seen and what was reported, these types of injuries do make you concerned that there could be some underlying head trauma given that of what the puppy endured. And there's different levels. So you can have head trauma where the animal is completely functional, and you still, given the type of trauma that the animal went through, you do have to suspect that you have to consider the body systems that could be involved, and one of those is the head, and that is considered, a rule out for head trauma.
Okay, so you ruled it out, but I'm a little bit confused because you didn't. So it should say R/O rule out head trauma. That's what your report should read, then, right?
So no, it's the rule out. It's not necessarily ruled out. It's the rule out. So in veterinary medicine, you place what your assessment is, and then you have your list of rule outs. So it wasn't necessarily ruled out, but this is part of things that could occur given the assessment of the pet.
But it's speculation there, right? So you can't say for certain then if it's on that list.
It's not a speculation, it's a rule out. So we are trained to be able to provide the different the different alternatives that either could be underlying, that don't necessarily demonstrate itself, or that that could have been a potential with this type of injury.
All right, we can go off the record for a moment. My understanding, this is a Delbert hearing. So my question is, for me to make a decision on whether or not she should be allowed to testify, what is she here as an expert in? What is her background? What is her opinion? And what is she basing that opinion upon? If people want to cross-examine her, then that needs to be done at trial. But specifically, what is she here as an expert as? What opinion has she come to? And what and her expertise, if she is she basing that opinion on? So we're going to take a brief reset. Counsel,
Yes, Judge.
are you ready?
Judge, I am not ready. We are waiting for some plea paperwork.
Okay. All right, so we're going to take a 5-minute break so they can print out plea paperwork, and then we'll get back on track. All right, Dr. Gilbert, if you'll just give us a moment, all right?
Yes.
And if you want to take a break as well, you're more than welcome to take down your video on your screen for now, and then we'll call you back. And it'll probably be about 15 minutes.
Okay.
All right, Maria Cisneros. Hello. Hi, why were you late for court?
Because I was at work. I wasn't aware that I had court today.
All right, you had court today. And here's the thing. Court is at 9 a.m. in this court.
Yes, ma'am.
And when you don't appear, what ends up happening is a warrant can be issued for your arrest. You understand?
Yes, ma'am.
Your attorney was here, but you were not. So you're going to get a reset form, and you're going to have to make sure that you appear on that date. You understand?
Yes, ma'am.
So you said you were at work. Are you the sole provider?
Homeschool provider.
Oh, so you at homeschooling?
Yes.
Okay. All right, just one moment.
Looks like you actually need to communicate with the court, because this is a constraint on her. And this is a constraint, and if she is innocent, she'll prove guilty. So this is a constraint, and I don't for her daughter.
But it's here's the thing. when people are on probation, there are certain conditions that need to be set to protect the community. Now, how old are these children?
They range from 2 years old until 6.
And they're not in school?
The other kids, I drive them to school.
All right. So I tell you what, council, we're gonna have a hearing about the condition of her bond, the conditions for her bond. We're not gonna have it today, but there are issues. She's actually homeschooling children. So we're gonna have a hearing about her conditions of bond. I know this is something new for you, council. You're just hearing about this today. So we're gonna reset that for your bond conditions, because I just don't think it's appropriate for her to have the charges she has and then she's homeschooling children. So we're gonna set that for a hearing. Now, with regards to the bond forfeiture, council, if you can talk with the bondsman and see if they have any objection to the court reinstating the bond, I'll reinstate the bond.
Dirk, I already talked to the bondsman, and I know they don't have any objection because they reached out to her to get her down.
All right. So we're gonna go on the record. We're on the record in 2025 CR 009530 State versus Maria Cisneros. Can I have parties announced for the record?
Melissa Alvin Sept.
Marshall B. White, Mr. Maria Cisneros, Your Honor.
And are you Miss Maria Cisneros? All right, Miss Cisneros, off the record, you informed the court and your and your counsel informed the court that you were unaware of the setting today. Defense has informed the court that the bondsman has no objection to the court recalling the bond forfeiture and having the bond reinstated.
That's correct, Your Honor. As I indicated, I reached out to the bondsman, and they facilitated Ms. Cisneros's appearance here this afternoon, Judge.
All right, so if you all will put that in the system to recall the warrant and reinstate the bond, and then we need to set this for a hearing on her conditions of bond. And
Judge, I have some weird situations going on in October that I do not have control over with respect to jury duty, not only in state court, but federal appeals.
Okay.
And I do not know, when I might be part of a.
well, will you be able to do it for by Zoom potentially?
I think that probably would be more accommodating for me if I could do it by Zoom.
All right, we'll set it by Zoom. And what I'll do is I'm sure it'll probably take some time for her to take care of these issues as far as homeschooling. So what I'll do, Norma, let's recall this back for October 6th and just note that Mr. Marshall may have to appear by Zoom. And they will give you the link and you need to be in court at 9 a.m. October 6th by Zoom. In person, all right? All right, they're gonna give you a reset form to sign.
Thank you, Judge.
All right, thank you.
Thank you.
Have a seat, ma'am. Have a seat.
Hello.
Yes. All right, we're back on the record. Defense, you may continue.
Yes, Your Honor. And at this point, we just asked the state to clarify what they're asking to offer Dr. Got Better for.
I'm sorry.
What specifically are they offering them for? I believe that can save us a lot of time here, Your Honor.
Yes.
Dr. Got Better, an expert in veterinary medicine, actually testified underneath that knowledge and training and experience. It includes shelter medicine as well as cruelty and behavior assessment.
You said cruelty and behavior assessment?
Yes, sir.
All right, they said that they're going to be offering her, and you're offering her as an expert witness in veterinary medicine, shelter of animals, and cruelty and behavior assessment.
Medicine, cruelty and behavior assessment.
All right, so they say that's what they're labeling or offering her expertise in.
And Your Honor, the only part that we really, and I'll try to wrap this up quickly, the only problem that we have is with the cruelty and behavioral assessment.
All right,
part of
so Are you stipulating then that she's an expert in shelter medicine?
Yes.
Yes, Your Honor.
And are you stipulating that she's an expert in veterinarian medicine?
Yes, Your Honor.
And so the only objection you're having, you will not stipulate to her expertise in cruelty and behavior assessment?
And the process and, by which this was done. And I just have a couple of follow-up questions regarding that, Your Honor.
Okay, so just so the record can be clear, the defense is stipulating that she's an expert in veterinarian medicine and shelter medicine. You're not stipulating to her expertise in cruelty and behavior assessment?
And more specifically, how it was performed in this particular case, as applied here.
All right, so then since this is a Daubert hearing, focus on her expertise or lack thereof in cruelty and behavior assessment, and then we can go from there.
Understood, Judge. Okay, Doctor, can you hear me again?
Yes.
Okay, all right. So I want to start off by asking, you testified previously about, the dog's response to certain stimuli. Did you introduce the same stimulus that caused the blunt force trauma? Were you able to introduce that to the dog to see its reaction?
No, but it is not appropriate and indicated.
Okay. So you would agree that blunt force trauma and then, for example, loud voices, as you reported as a stimulus, those two are not the same and could cause different reactions or responses, right?
Blunt force trauma is the assessment part of it. So when an animal goes through trauma that was blunt force, whether or not it demonstrates that there are residual wounds or not. The submissive is part of the behavioral assessment.
No. Okay, but as to that's part of the assessment. You spoke earlier as to stimulus and response. You were not able to show the animal, the dog, the object that caused the blunt force trauma. Right. Is that correct?
I don't understand the question. Show the animal what object and what stimulus. So the physical examination is to look at the behavior of the animal and read the animal's behavior. It is part of the actual medical assessment. And so behavior there is a medical component in there. And so that is what was completed, a full physical exam, which included the animal's behavioral response in that moment.
Okay, and you viewed the video, correct?
That is correct, yes.
And those are responses, the responses that you observed were based on stimuli that is not similar to what could have caused blunt force trauma, right?
Well, both situations are completely different. One is the video of the animal that was undergoing striking and a different type of handling versus my physical examination, which is it's a medical physical examination and behavioral.
Did you prescribe the dog any medicine?
At the time, the pet did not, what the pet required was the appropriate handling and interaction and the husbandry that comes with having a puppy.
But you would agree that responses to the loud voices alone is not enough to cause or assess blunt force trauma, right? That on its own.
Oh, correct. Yes. The responses to the loud voices is the part of the medical examination of what was identified. The blunt
Okay.
force trauma is the assessment of the totality of the history, the video, and then the examination together.
Okay. And the fact that the puppy froze, or that part that you found in your physical examination, that alone is not enough to assess blunt force trauma just on its own, right?
Correct. That is the behavior of the puppy in that moment. That is the behavior of the pet.
So a majority, or your finding, your assessment really is based primarily on the video, correct? Did that play a
No.
large role?
No, the assessment of blunt force trauma is the totality of the history, what was observed, and the physical examination with the behavior. So all of it together in its totality is demonstrating that this pet endured blunt force trauma.
Including the video, right? Because that was part of the history of what you.
That is part of the history. So that is the full picture.
But there's no, based on what you observed, and you know, I'm not going to get into the prior report, but based on what you observed, there was no physical indication that there was blunt force trauma based on your examination.
Well, there was again that redness of the skin, but again, the blunt force trauma is an assessment that is the totality of everything.
So, do you have any idea that the redness that you observed definitively was due to blunt force trauma?
Not definitively. It was everything that was part of the physical exam findings. So, for example, if an animal is stabbed and you see some stab wounds, then there's an assessment of sharp force trauma. And so blunt force trauma, you can have different degrees of blunt force trauma. You can have some skin redness. You may not see any actual bruises. You may see bruises. You may see broken bones. It is an actual assessment of the totality of everything. So the physical exam, the behavioral part of it, how the animal is behaving with even just very basic interaction that not necessarily should be triggering the pet. And then of course the history, if we get that part of the history.
But the only two stimuli that you introduced to the animal that they respond to was the loud voices and the freezing upon examination. That was the only two responses that you noted or reported, right?
Your Honor. So it was the stimuli that was
just 1 second. There's an objection.
We were going to object. This is outside the scope of the Daubert hearing, as the court has already brought up. I feel like they're attacking the credibility of her opinion more so than her ability to give the opinion.
All right, so defense.
Your Honor, our response is that we're narrowing this down to the cruelty and behavioral assessment part of this. We are specifically addressing what she observed, what stimuli that this dog was exposed to. Was there anything else related to or in the same realm of blunt force trauma, behavioral assessment of this animal that leads to blunt force trauma? We have a right to examine how that was applied to get to blunt force trauma. The fact that there was no other stimuli that the dog was exposed to and reported in the physical examination certainly is relevant.
So if this is a Daubert hearing, which it is, and the issue for the defense is whether or not she's an expert in cruelty and behavior assessment, then it would seem to the court that there should be questions about her background concerning cruelty and behavior assessment. We can go off the record, i.e., how many times have you done cruelty and behavior assessments? What's your educational background and experience to do cruelty, behavior, and assessments? How many have you done in the past? And then, did you do a cruelty and behavior assessment in this case? How did you perform that? And then what are your results? And then state can ask questions, and then everybody can make their argument, and I will give my ruling.
I believe the problem we had, and you know what it took to get there, is because we weren't able to identify what exactly that they were offering the expert for. I think what it goes to, what I'm trying to get at here, is the reliability of the application of the theories that she's relying to the facts. That's really what I'm trying to get after.
All right, so if y'all just ask her the question, what, what's your background in this? Which I think you all may have already asked that question. If you have not, asked that question. And then after you ask that question, then did you perform a cruelty and behavior assessment? How did you perform that cruelty, behavior, and assessment? And what did you do specifically to perform that? What tests did you run? And then based upon your assessment, what's your conclusion?
Understood, Judge.
Right.
All right, so let's go back. As far as the behavioral assessments that you've made in this case, what studies are you relying on to make those assessments?
I'm not understanding the question regarding studies. A physical examination with a veterinarian requires the veterinarian to assess not only the physical aspect of it, but the behavioral aspect of the animal. And that is just something that comes natural when you are performing the physical examination. You need to ensure that you can read the animal's behavior. So it is not, this is part of our training when we are performing physical examinations on any and all animals. When it comes to cruelty cases, you definitely pay attention to any other types of behaviors that may demonstrate themselves when you're performing the physical exam. It's not essentially you have to provide all these stimuli to identify inappropriate behavior. The normal handling and interaction with the animal will demonstrate the inappropriate behavior to surface on its own.
What studies specifically, as far as the behavioral part, the freezing and the sensitivity to loud voices, what studies, methodology, anything are you relying on to make the assessments you made based on your behavioral observations as to those stimuli?
Yeah, so there is a methodology when you're assessing the behavior of the animal. I'm not sure about what studies you're looking for. They have different, there's in the behavioral aspect of it, there's information about, what fear is, what aggression is, but again, the methodology is the first step is you introduce yourself to the pet and you read the behavior of the pet prior to touching the animal. And at that point, it is what was performed, which was on that day of the exam, the puppy was bright, alert, and responsive. It was active, it was playful, it was walking around, it was ambulatory. It did retract when there were loud voices around. And just, very just sensitive to that. And then once we went ahead and started the handling part of it after the introduction, then yes, there was the puppy froze in that moment with the handling and the evaluation. So there is a methodology to when you are doing your physical exam and you're incorporating behavioral assessment in there as well.
But how does the behavioral assessment relate back to the cause of the trauma? Based off of any study, scientific study, anything that you can name?
Yeah, so the behavioral assessment with any cruelty case, especially when you're provided a history, you do need to be sensitive to that and identify, has this animal had any form of fear imprinting? And animals can have fear imprinting even if it's from trauma or no trauma, and you have to be able to identify that. So there are, there's articles on fear imprinting. There's information, just like there's articles on, an oral exam and how that is performed. So it's just part of the encompassing training that veterinarians are provided. And so, for example, for behavioral assessment, when we do our continuing education courses, when we do our normal, national rounds, we discuss cases on, cruelty cases where we talk about behavior of an animal that has endured cruelty and what do we typically see. And some of those behaviors are a little bit more pronounced than what you would see with an animal that has not undergone that. So that was part, so the methodology was there, and that was part of the rule outs of the fear imprinting.
Okay. So did you rule out fear imprinting? Was that something that was a rule out?
It wasn't, again, when you have R/O, that's considered a rule out. So those are the potentials of the assessment of what a blunt force trauma can do. So blunt force trauma, there's a form of neglect of care. There could have been head trauma. There could have been some spinal injury or cervical trauma. I also listed chest trauma, and then fear imprinting. And so that is a rule out, meaning that is part of the list of potentials that could have occurred.
Could have, but you can't say for sure, right? For those list of things.
Correct. That is something that it is part of the rule out. It is in the line of what you would anticipate with blunt force trauma.
I'll pass away.
Certain parts of it go together, and certain parts are a potential.
Go better. This defense has said they're passing the witness.
Okay.
All right, state, any questions?
Yes, Judge, very briefly. Dr. Got better, can you hear me?
It's a little hard to hear you. You're a little distant.
Can you hear me now? Is it better?
It's still a little far.
It should be.
need the mic that they got over there.
Okay, I'm sorry.
I'm sorry, Judge.
No problem.
I feel like the right. Okay, Dr. Got better, can you hear me better?
Yes. Yes.
Okay, perfect. You mentioned national rounds. What is a national round?
So national rounds, we are part of a group with University of Florida and UC Davis shelter medicine that we do weekly national rounds. So all veterinarians that are within this area of expertise, mostly shelter medicine or with rescue organizations. And we even have some private practitioners. Again, they're veterinarians, national veterinarians that all come together and discuss cases. And those cases can be cruelty cases. They can be a little bit more specialized types of cases, orthopedics or whatnot, or critical care, and we go over it. We also do kind of population medicine. So this is just it's one of the groups that I'm a part of that performs national rounds.
Is national rounds kind of like a peer review situation?
Yes, that is correct.
Okay. And you said you do this weekly?
Yes.
And approximately how many cases would you say are staffed? Is that a fair statement to staff cases with each other?
I've been doing it for years, so I don't know how many cases. But it is, I've been doing it for years, so
Okay.
it's yeah.
That's perfect. And you stated years. Do you have an approximate amount of time that you've participated in national rounds?
Ever since I've been in shelter medicine.
And how long is that?
Well, so I've been in shelter medicine over 10 years at this point.
Okay. And in your training and experience, I believe you said that how long have you been a veterinarian? I'm sorry.
Since 2009.
Okay, so since 2009, have you received training on animal cruelty?
Yes, so prior to working with animal care services, I did work in emergency and critical care. And at that point, we were servicing the shelter for cruelty cases. So I was seeing that other side of it, of animals on the day of intake needing an examination by the ER veterinarian. So I performed those examinations and then transferred, did whatever treatment is needed, and then transferred the case over to the shelter veterinarian.
So is it you?
Excuse me, just 1 second, off the record for a moment. So we don't allow hugging in court. All right, thank you. All right, you may continue.
So is it your testimony that you've had practical experience in dealing with cruelty cases?
Yes, I've at least ever since being here at Animal Care Services, I've been dealing with all the cruelty cases and the confiscate cases that the shelter has to service for the city of San Antonio. And that has been since the time that I've been here. I mean, at this point, it's countless. I don't know how many cases it's been.
Okay. If you had to estimate, how many cruelty assessments would you say you've performed?
I would say like hundreds. I've
Okay,
done them over the years. Yeah.
Okay, and how do you perform cruelty assessments?
So it's, you know, first it's being provided the histories, if there is any history that can be provided. And then sometimes we don't have any history at all. And then we move forward with our physical examination and assess the animal from there.
Okay, what specific training do you have that allows you to perform cruelty and behavior assessments?
So, I mean, the first training is all veterinarians get trained in performing physical examinations, behavioral assessments, and then they do get a training in understanding shelter medicine and what it encompasses. So, those rotations do include cruelty assessments, understanding court processes. We get that training, and then yearly continuing education that is provided on the shelter medicine track. So there's training even with Dr. Melinda Mark, that goes over necropsies and cruelty cases and the different types.
Does that training include recognizing trauma in animals?
Yes.
So you stated that y'all learn various techniques, correct? Are the principles and techniques that y'all are taught reliable?
Yes, I mean, our physical examination findings are will help to guide us in the direction of providing that assessment.
Are the principles and techniques employed throughout the day-to-day? How are they a hallmark of your field?
Yes.
Yes. Are the principles and techniques that y'all have been taught to rely upon, are they widely used across the veterinary field itself?
Yes.
And then in your day-to-day life, how often would you say it is that you employ your techniques and principles regarding animal cruelty and behavior assessments?
I mean, it's daily. Every examination comes with us assessing the behavior component of it, and identifying that is just, you know, that is what is needed for it to be a complete physical exam. And then of course the cruelty cases, it can be daily, it could be multiple times a week. For the most part, I mean, we do get a lot of different cruelty cases or confiscate cases.
You testified, Dr. Gottbetter, that fear imprinting is something that may be observed when assessing behavior, correct?
Yes.
Okay, how often would you say you encounter fear imprinting in animals on a day-to-day basis?
We get different levels of fear imprinting, and so I see it with the shelter pets, and different cases that come through. So I would say day to day.
What principles or techniques are used in assessing whether an animal has signs of fear imprinting?
So we look at if the response to the stimulus is appropriate to the level of the stimulus. And the stimulus is just the environment that they're in, and not necessarily trying to create a stimulus. It's more of when you are interacting with that animal, or you see that animal, for example, in the shelter, and you see a certain behavior, is it in alignment with the stimulus that is surrounding that animal? Sometimes it is, sometimes it is not. And when it is not, then it number one, we have to do something about it. We have to ensure that we make those adjustments to make the pet more comfortable. And then number two, we need to ask ourselves the question, why is this animal having this type of stimulus when in general it's not, response to the stimulus when in general, they it wouldn't be the normal response that we would see.
So although animals and situations vary, right? Are there any things that are kept constant to help you determine whether you are observing fear imprinting? Does that make
Sure.
sense?
So what can be kept constant is how you follow your, again, back to the methodology, how you follow your process to do your examination. So you introduce yourself to the animal, you read the behavior, you read their body language, and then you adjust accordingly so that the animal can be made as comfortable as possible. And then you move forward with your physical examination. You try to identify, where is the most appropriate location for the physical examination, who are your handlers, how, what type of handling are we going to have? If we need equipment, we may need equipment. Sometimes they need muzzles, sometimes they don't. And so the first step is assessing that patient to see what is needed in that moment. So yes, there is a methodology to it as long as you remain consistent. And again, the consistency is what's important. And if you weren't consistent, then you can always take a step back and then see if the animal does respond again to that, and then make an assessment from there.
Okay. Have you had any continuing education regarding fear imprinting or behavioral assessments of animals?
Yes, I actually train the 5 freedoms. So I provided training for that, and that it does talk about one of the freedoms is fear from distress, anxiety, and so yes, I mean I've had formal training on that. And that again is part of all veterinarians training to understand behavioral side of it when they're performing the physical examination.
And you stated the 5 freedoms. What is the 5 freedoms, or what are they?
Sure. So there is in general in the animal welfare world, and this is a principle that was created in the UK in the 1900s, and essentially it is the main 5 freedoms that every animal is entitled to. This is something that is across the board, can be utilized in the animal welfare world, whether it is for lab animal medicine, whether it's for livestock. And it was created because of inconsistencies with livestock. So, and it can be for shelters, for rescue organizations. And so essentially it is freedom from hunger and thirst, freedom from pain and discomfort and distress, and then freedom to express normal behavior. And so it essentially goes over what animals are entitled to for the very basics.
And are all veterinarians taught this in veterinary school?
That is correct, yes.
So they're foundational principles in your field?
Yes, yes.
And you provide training on this to other vets?
Yes, I do. Yes, yes.
How often would you say you provide these trainings?
I provide this training probably every academy training that I have with the animal care officers. So every time we have a new class, and it's about I want to say a 6-week program. So it is part of my trainings that I provide for the animal care officers.
So if you had to estimate, how many times a year would you say you give this training?
Probably 2-3 times a year. That's just for the academy class. And then I do provide training for the shelter staff and the veterinary technicians. So it is dependent on the need. And there's some rescue organizations that we have done the training for so that we can help guide them when they are finding placement for animals and understanding how they're going to be able to provide husbandry care for those animals until they can find permanent placement.
So regarding Thanos, in this case, did you form an opinion as to whether he had experienced trauma?
Based off of the information that was provided, the history, and then myself with the physical exam and the behavioral assessment, it is the assessment was blunt force trauma.
What about fear imprinting?
That is a rule out, so that is a possibility, that this animal could have, developed fear imprinting. That is something that, it was a rule out. So it's a possibility.
You stated you observed the video in this case, correct, Dr. Gottbetter?
Yes.
Based on your review of that video, did you make any observations regarding whether the dog was experiencing pain at the time?
So yes, in the video, there was, again, you can see the behavior of the puppy, in the video. I did make note that the puppy was, vocalizing, and the behavior was in a submissive position, during the incident.
And study of vocalization in animals, is that something that's taught in school?
Yes, we do learn about different sounds that can come from animals, and what they mean. There is cats, for felines, for example. There's different types of vocalization that will let you know, if this is a form. It's essentially a form of communication, and if this is a form of distress, or if this is a form of pain, or if this is comfort. So animals will vocalize, and based off of the type of vocalization, it can tell you, is there pain, is there discomfort, is there distress, or are they comfortable? Are they content? And so that's, so we do learn about that, and that's part of the behavioral aspect of it.
Okay. And then is the behavior you observed in the video consistent with blunt force trauma?
The incident that had occurred that was demonstrated in the video is consistent of blunt force trauma, given what was being performed on the pet, which was, the striking.
And then in reaching this conclusion, did you rely on the principles and methodologies that you've received in your training?
Yes.
And did you apply them correctly?
Yes.
No further questions, Your Honor. I pass the witness.
Any follow-up?
Okay. Just to be clear, are you concluding that the dog felt pain at the time of the video? Are you saying that?
So no, I'm not concluding that that specific. I am concluding that in the video, the puppy was vocalizing, and in a behavioral position, that demonstrated that the animal was in that type of discomfort.
All right. Did you perform a cruelty test that you referred to in this case?
I don't understand the question. What cruelty test?
Is there a specific cruelty test that you did in this case? Specific, is there a test that you do specific to cruelty case or assessment?
There's no specific, like the term cruelty test. It's a cruelty exam. So there's no actual tests are, for example, like diagnostics. So, we do some blood work, or we do, we do other types of diagnostics. A cruelty test is more of like it's essentially a cruelty examination. So in the veterinary world, we do a cruelty examination. A cruelty examination is not necessarily going to be, it's essentially not a cursory exam. It is a full exam that takes everything into consideration as much as the information will allow.
All right. And you mentioned blood work. You didn't request or take blood work as part of your examination, right?
If it is not indicated, no. So no, we did not take blood work for this pet.
Okay. And just to be clear, for purposes of the record, did you perform a cruelty examination in this case?
Yes, the cruelty exam was the full examination with every aspect of it involved. Yes.
All right. We'll pass the witness, Your Honor.
Any further questions?
And from the state, Your Honor.
All right, is this witness excused?
Subject to recall for the.
for a trial.
All right. So you're excused. You may be recalled for purposes of jury trial, but for purposes of this hearing, you're excused.
Thank you, Judge.
All right, thank you. And this other person who's here for a witness, who is that? Jared Hall?
Oh, no, it's.
Oh, that's my laptop.
Oh,
Your Honor.
thank you.
Yes, Your Honor.
All right, I'll let you all formulate your thoughts. And while you all are formulating your thoughts to present the argument to court, I will take up this plea. All right, Freddie Gonzalez. All right, court is calling 2025 CR 012008, State versus Freddie Gonzalez. Can I have the parties announced?
Christopher Ramos and Paul Savedo for the defense.
All right. So in this cause number, counsels, have you received all discovery? Did you review with your client?
We did.
Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, Your Honor.
Did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure with your attorney? Did you understand it?
Yes, Your Honor.
Did you understand your attorney and you have certain rights? You have a right to have a grand jury hear the evidence in this case and make a decision on whether or not there's sufficient evidence to hold you over for a jury trial. Your attorney also has certain rights. They have 2 days where they're entitled to 2 days to pass upon presentation of the information to them, and also 10 days to prepare for trial. Did you understand?
Yes, Your Honor.
Did you understand by entering into this plea, you're giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Did you review the information with your attorney? Did you understand that?
Yes, Your Honor.
Counsel, do you waive the reading of the information?
We do.
State, are you proceeding on the information as presented?
We are.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
Yes, Your Honor. Oh, no.
Has anyone promised you anything other than this plea bargain agreement?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, sir.
Did you understand by entering this plea, if you're not a U.S. citizen, you will be deported, not allowed re-entry into the United States, and denied naturalization?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at 10 years in the prison. There's $1,000 fine. The state recommends community supervision. This is run concurrent with 2025 CR 005706. I'm sorry, it's 2025 CR 005206, 2025 CR 007487, 2025 CR 007397, 2025 CR 009295. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
That is right.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counselor, there have been such motions.
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 10 years. There be a TAP evaluation, 150 hours community service restitution, and in the MRT. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
Then to the offenses charged, how do you plea?
No contest.
State any evidence?
State representative evidence states exhibit 1 with its attachments.
No objection.
All right, did you review the waiver and consent to stipulation and testimony with your attorneys? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Sure.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. Court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Yes, Judge.
Anything you wish to say on behalf of your client?
Yes, Judge. We ask for it to be mindful that he is gainfully employed right now. This plea is a part of a larger plea that took place 2 weeks ago. The court asked us to return to provide some restitution. And the court also asked the state to provide documentation of restitution amounts. At this moment in time, I don't think that the state has been able to verify the various restitution amounts. But our client does have a significant amount of money to provide in terms of restitution once the state's able to verify those amounts.
We have tried vehemently, Your Honor, to get restitution amounts from all of our different victims. Some have said that they have restitution and will get us the documentation. They just haven't been able to locate it or provide it to us yet. Some have said they don't have any restitution, and there are a couple that we have not been able to get in touch with.
All right, so in this cause number, the 2025 CR 012008, restitution?
On this evading in a vehicle, no, Your Honor.
All right, what about the vehicle? Because it says that the vehicle was damaged with a screw.
Oh, I'm sorry, Your Honor. This one is related to another case. Yes. That is one of the people that we reached out to, and they have not given us any documentation.
All right, how old are you?
30.
You're 30. And this happened on or about May 7th, 2025. Explain this to me. Why are you, honestly, I don't even know why I should accept this agreement you've reached, because you're picking up evadings, forgeries, thefts, unauthorized use of a vehicle, another theft, manufacturing cases, and unauthorized use. So why should I follow any of these plea bargaining agreements?
I can offer the following, Judge. All of these cases deal, for the most part, dealing with financial or property crimes. At the time that he was committing these crimes, he was experiencing significant financial hardship. While that is not an excuse, if you have, not to be harsh, but if you have any sort of discussion with him, he not a very sophisticated individual. And I think as he's described, he took it upon himself to steal this property, sell it for funds, but he didn't realize how he was going to get caught. He thought this was too easy. So he continued, and if you look at the time frame of all of these offenses, they took place within a short matter of time. That's when the offenses caught up with him. He's a very unsophisticated individual. He thought he could get away with this. He was caught. I think even one of the offenses had a GPS tracker on them. He just did not think this through, because I think part of me thinks that he is, not to be harsh, but unable to think this through.
But he's able enough to get a Louis Vuitton belt. A regular leather belt you can get is $20, and you put the LV on it. That leather belt goes up to, I think, a minimum of $350. So he's sophisticated enough to do that. Unless it's a knockoff, and it doesn't appear to be a knockoff to the court based upon my experience.
I honestly wouldn't know how to tell a knockoff from an authentic Louis Vuitton.
Oh no, that's a Louis Vuitton belt.
Is it?
So you want to, yeah,
But
I can spot the knockoffs.
And as the court inquires with him, you'll see that he just is incredibly unsophisticated. In terms of
being articulate, thinking things through, thinking that he could get away with it. So at the end of the day, he does have significant amount of, I consider significant, to pay the restitution off to these individuals if they can verify the amount. And if this restitution can be made whole to these individuals, it could be to their benefit as well.
All right, and what's the amount of restitution he's here with today?
He has informed us he's in position to provide $5,000 in restitution. All that we ask is that those amounts be verified by the complainants.
He probably could have had 6,000 if he wouldn't have had the Louis Vuitton belt.
Good. That point, if I may, I know Chris has been, if I may, Your Honor, one of the ways he was able to raise the money was selling things that were near and dear to him. One of the items that he sold, ironically, was his vehicle. So as we speak right now, he is vehicleless, which is kind of ironic considering the charges that he has.
Ironic, but understandable.
And he did liquidate items that he could sell, and he was able to raise $5,000. That doesn't mean he's stopping. He's still trying to sell stuff. And for all I know, maybe the belt is one of the things he's trying to sell. But he has been liquidating his assets. Back to the earlier question. At one point, through hard labor and diligent work, he was able at one point to afford a nice living. He was working in the aggregate business, which is basically shoveling gravel and dirt and so forth. And at one point he was able to make a decent living. And then I don't know if you can notice, he has been having problems with an arm of his that is the result of a birth injury that has been progressively getting worse with his age. And his means of earning that living kind of caught up to him with his disability. Prior to this, he's 30 years old. He has no criminal history. He thought he was going to be able to do something, and he just was not able to. He caught up with it, got caught. And do I feel like he's remorseful? I feel that way. Of course, it's not me experiencing his feelings, but I do. He has expressed regret. For all we know, maybe the regret is because he got caught. But he does express regret. He is trying to show some redeeming value. He has a young child that is about maybe 4 or 5 months old. How old is your child? 4 months. 4 months old. He's never been on any public assistance. He's never received food stamps. He supports his wife. He is legally married. He supports his children. And he just made some decisions. And I've asked him, why did you do this? He's kind of dumbfounded.
And I think he would happily sell his belt in order to add to the restitution. I am mindful that there are some individuals that, and I don't necessarily follow this thought, but there are some individuals that believe by showing respect, by wearing their best, and some people believe name brands is the best as a sign of respect to the court. And I would ask the court to consider his appearance and his willingness to look his best or present himself in the best way as possible.
No,
It's unfortunate that he chose a Louis Vuitton.
No. I only bring it up because we're here because the argument is that he had no money. And based upon that Louis Vuitton belt, that Louis Vuitton belt is not this season. So that's something he had prior to this. And I just based upon my limited expertise in the field.
And of course, Judge, at one point, he was able to earn a living through hard labor. You know, working with aggregate is not an easy.
But why didn't you sell off your Louis Vuitton and all of this stuff before picking up these cases? And why, state, should I follow this agreement?
Your Honor, this was an agreement that was entered into a while ago, and my understanding is that the defendant made strides as far as improving himself, and that was what was communicated to my colleague when they decided to offer this deal.
And what does he do for employment?
Employment right now, he's still dabbling in the aggregate. He's trying to get into the transport of aggregate, and he's working in that avenue right now.
Right, when we say dabbling, so is this a full-time job or no?
He has a truck that is in disrepair, an aggregate truck with a trailer, or do you have the trailer also?
No.
He has the trailer also, and and they're trying to repair the truck to put it to work.
So he hasn't been working.
No, he still works within the industry, but he's just not making as much money as he.
I'm not driving a truck.
Are you still working?
Yes.
You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record. State your name for the record.
Freddie Gonzalez.
All right, so are you currently employed? What do you do?
Oh, I'm working with load. Right now, I'm working with it's the same thing. Well, I don't drive the trucks anymore, but we load them up in the yard and with aggregates and like bays and stuff like that. I'll operate the machine.
All right. Any other questions? All right, this is what the court is going to do. In 2025 CR 012008, court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors. This is to run concurrently with 2025 CR 005206, 2025 CR 007489, 2025 CR 007397, 2025 CR 009295. There's to be field visits one time per month for 6 months. There's to be 150 hours of community service restitution. 50 of those hours will be deemed satisfied upon completion of parenting classes. And there's to be, and you say you're currently not driving, you don't have a vehicle?
Yeah.
All right, there's to be no driving without prior court approval.
Judge, may I, just for future reference, the truck that they are working on to deliver aggregate, will you reconsider once that truck is repaired? So they can go work? Thank you.
And there should be 10 days in the Bexar County Jail as a condition of probation, and that will begin on, and you'll need to turn yourself into the jail. Deputy Mejia, do y'all want him to turn himself into the jail or turn himself in here?
The jail is easier.
All right, so, and you're gonna need to turn yourself into the jail no later than October 10th. Oh, October 10th. Yes. No later than 5 p.m. Did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorneys? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. In 2025 CR 007487, the court previously found you guilty The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's $1,000 fine that will be probated. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, and 1208. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits one time per month for 6 months. 250 hours of community service restitution. 100 hours will be deemed satisfied upon completion of the MRT, which is being required. The remaining 150 will be deemed satisfied once he completes the anti-theft course. And there's to be no driving without prior court approval. And 10 days in the Bexar County Jail as a condition of probation, beginning October 10th by 5 p.m. And you'll need to turn yourself in the jail by 5 p.m. on that date. And that cause number, did you review the document? And oh, I'm so sorry. Also, the state is taking in consideration 2025 CR 007488, 007406, and 009170. And Norma, in each of those cause number, I'm going to need a reset date in 30 days for restitution. All right, in that case, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Again, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you will need to speak to an attorney. Do you understand?
Yes, sir.
And cause number 2025-005260. The court will sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits one time per month for 6 months, no driving without prior court approval, $10 days in the Bexar County Jail as a condition of probation. You're to turn yourself in no later than October 10th. I'm sorry, you're to turn yourself in on October 10th by 5 p.m. There's to be 250 hours of community service restitution. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. Taking consideration 2025 CR 007488, 007406, 009170. Yes. Yes. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. We're moving on to 2025 CR 005205. And that cause number punishment is to be assessed at 2 years in the state jail facility, suspended and probated for 5 years. There's $1,000 fine. This will run concurrent with 2025 CR 007396. There is to be restitution of $500 to Elizabeth Mascaro. There's to be no contact with Elizabeth Mascaro. And with regards to that complainant, does he have a money order for $500?
Yeah,
Yeah,
cash.
yeah, I have to.
No, not cash. They don't.
He doesn't have a money order, but
Do y'all accept cash?
I don't think they do.
All right.
He wants to go get one and bring it back.
So you'll need to have a money order, bring it back tomorrow. Either your attorneys can bring it tomorrow. A money order for $500 made out to Elizabeth Mascaro, and you're to turn that in to the DA's office.
And which case number is that, Your Honor?
That's 2025 CR 005205. There should be 100 hours of community service restitution, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior approval from the court. There should be 10 days in the Bexar County Jail. You to turn yourself into the jail on October 10th by 5 p.m. And there should be field visits 1 time per month for 6 months.
Judge, for clarity,
Mhm.
what is the name of the $500 check?
According to your agreement, it's Elizabeth Mascaro, Mascorro. Did you review the trial court certification of defendant's rights to appeal in that cause number with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak with an attorney. And cause number 2025 CR 007937. Court will sentence you to 10 years in the prison, suspended and probated for 10 years. There should be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home health care provider or with minors, no driving without prior court approval, there's $1,000 fine. This will run concurrent with 2025 CR 005206, 007487, 007397, 009295, 005205, 007396, 012008. State will take in consideration 2025 CR 007488, 007406, 009170. There should be no contact and restitution to Adam Vasquez. There's 10 days in the Bexar County Jail as a condition of probation. You're to turn yourself in on October 10th, no later than 5 p.m. And there's to be 150 hours community service restitution. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Sure.
And Norma, if you could start working on the reset form for him. All right, cause number 2025 CR 009295. Court is going to sentence you to 10 years in the prison, suspended and probated for 10 years, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits 1 time per month until further notice. This is to run concurrent with 2025 CR 005205, 007396, 005206, 007487, 007397, taking consideration 2025 CR 007488, 007406, 009170. There should be no driving without court approval. 150 hours of community service restitution. 10 days in the Bexar County Jail. As a condition of probation, you to turn yourself into the jail on October 10th by 5 p.m. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. In 2025 CR 007396, court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. There's a $1,000 fine. This will run concurrent with 2025 CR 005205. There's to be restitution to Mark Crofton, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days, no employment as a home healthcare provider or with minors, field visits 1 time per month for 6 months, 10 days in the Bexar County Jail. As a condition of probation, you to turn yourself into the jail on October 10th, 2025 by 5 p.m. There's to be no contact with Mark Crofton, and there should be 100 hours of community service restitution. Probation in any of those cases, is there any other condition that is needed? Yes. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it
Yes, Your Honor.
and sign it?
Yes, Your Honor.
Right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question on what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Ms. Ferguson, what date for restitution hearing? All right, so we're going to be back here on October 30th for restitution hearings. Make sure that when you come back on that date, that you have money orders.
Mayor Pro Tem?
Yes. All right, we can go off the record. Here's the thing. You're old enough now in your life to know better and do better. And there is no excuses for your behavior. You understand?
Yes, sir.
If everybody who had some sort of issue where they lost their job or something didn't go their way, if they decided, you know what, I'm just going to throw my hands up and I'm going to start committing crimes, then where will we be? We would be in the world of Mad Max, and this is the United States, and you're not allowed to do that. Do you understand?
Yes, sir.
So from here, from here, everything you need to ask yourself if this could result in your being placed in prison for up to 10 years or up to state jail facility for 2 years. If the answer is yes, don't do it. If the answer is maybe, don't do it. Do you understand? All right, good luck to you.
Thank you, Judge.
You're welcome.
Appreciate your time.
Thank you. All right, so we're back on the record in 2025 CR 001454. Defense, it's your motion. You may proceed.
Yes, Your Honor. At this time, I'd like to formally make our objection. Specifically, our first objection is as to Dr. Godbetter rendering an opinion or mentioning fear imprinting, because by her own admission, she can't rule it out or in this case. It would be confusing to the jury. It would be misleading to the jury to present expert testimony on that topic. Due to the fact that she can't rule it out or in this case, it doesn't push the needle either way.
Isn't that more for a motion in limine or for cross-examination, but it's not related to whether or not she's an expert in the field?
Well, we believe that it falls within the topic that they're agreeable to keeping that out, and that's outside the scope of what they're offering. There's a difference between her expertise and the specific findings in this case. We're asking to exclude her testimony as to any questions regarding her responding to whether the dog felt pain at the time of the video. We believe that invades the province of the jury. She did testify to that today. We originally filed a request for what she was going to testify today as far as a specific area, and we didn't get that until today. The state provided witness list did not provide that. So to that extent, both of these specific topics, this is the first time that we've formally been addressed. That's what she was going to testify to. The 4-day delay, when we look at the analytical gap between the assessments and findings and what Dr. Godbetter is going to testify to, there's a 4-day delay. We believe that would be confusing, misleading, and unfairly prejudicial for her to be able to make these findings based on that delay.
But, all right, so let me ask you this, because I just want the record to be clear. My role in this hearing is to make a determination whether or not she's an expert, what field she's being offered as an expert, and then what are her conclusions? Are these conclusions based upon what she's viewed in the realms of her expertise? So other arguments that y'all may have, that sounds like more arguments for cross-examination. So I'm just here, what is her area of expertise? And my understanding is that parties made certain agreements or stipulations that the only area that the defense was saying she was not an expert was as it relates to cruelty and behavior assessment. So if everybody can focus on what is her background in cruelty and behavior assessment, and if it's determined that she's an expert, is she using her expertise based upon any type of examination that she's done to come to a certain conclusion. But everything else, it's cross-examination.
Understand your big problem is with the conclusions that Dr. Godbetter has made. Her application of whatever training or expertise that she has to the facts of this case. The reliability of that, how reliable was her application of the fact? And we contended it was unreliable, specifically as to the areas that we mentioned. Based on her own testimony today and what she wasn't able, I believe a bigger part of the problem was what she was not able to testify to. She was not able to testify to fear imprinting occurring in this case. Her conclusion that blunt force trauma, as it pertains to the application of the behavioral assessment that she says that she did for this animal, we believe that the application of that was unreasonable and unreliable, and that we shouldn't put this before a jury to consider. Specifically, again, we would argue that what we stipulate to and what the state is offering doesn't include allowing her to invade the presence of the jury to testify that an animal 4 days prior, to allow her to Monday morning quarterback and say, hey, on this date, this dog felt pain, because that's pure speculation. We'd have to keep that out. We believe that, and she said that she could not testify to it, but we're asking that she not be, that not be brought up. The failure to rule out other causes is the other big issue we have. That can also be grounds to exclude expert testimony, and I'll cite Kia Motors Court v. Ruiz, which is 432 Southwest 3rd, 865. Experts have a duty to bridge the analytical gap, and here, when we add up the history plus the facts, they do not equal the assessment of blunt force trauma in this case. We contend that that application is unreliable, unreasonable, and unfairly prejudicial to us and doesn't have a factual basis from this case. As applied specifically in this case, the conclusions that Dr. Godbetter is making in this case. There's no specific fit between the scientific principles, the facts, and the assessment here. If an analytical gap has not sufficiently been breached, then the court can exclude it, and the court should exclude it in this case based on the application of the facts that was made and testified to here today. She makes a blunt force trauma finding without referring. Her primary focus of that was the behavioral assessment of the dog. No idea of what caused it. No bringing of anything similar or the stimulus to show that it was blunt force trauma, to show that the dog had a reaction to it. She doesn't say what caused the fear and prejudice or what, could have caused it. We're missing the cause here too. There's a huge analytical gap there. And we would ask that her testimony be excluded on those grounds. There's an analytical gap. She wasn't able to sufficiently identify the application of the facts to the law in this case, and we believe her testimony should be excluded on those grounds.
All right, state.
Your Honor, she would argue that Dr. Godbetter can give an opinion on animal cruelty and behavior assessment, and what causes fear imprinting in animals. She testified that the totality of the circumstances is what's relevant here, right? She said that she examined the animal history of the patient. She conducted a cruelty exam as well as reviewing the video. She testified that she's had experience since 2009. She's currently the chief vet of ACS, and prior to that worked in the animal clinic. She testified that she participates in national rounds, which functions as peer review. She performs training multiple times a year, as well as receives training through continuing education, which include animal cruelty and behavior assessments. She states that she also gives trainings for the academy classes of veterinary medicine. She also testified that she deals with this subject matter on a daily basis, multiple times per day. She also testified that she relied on the learned principles and techniques in performing her cruelty exam and assessment of the animal behaviors. These principles and techniques are rooted in long-standing methodology of veterinary medicine.
these principles and techniques are widely used and accepted in veterinary medicine across the country, as well as these principles and techniques being reliable. She testified that she correctly performed them in this case. We would ask the court that based on her skill, knowledge, education, expertise, and training, that she be allowed to testify to these facts, as well as the root cause of what may be causing the animal in this case to be exhibiting fear imprinting. For defense to ask that you not be able to do this would for defense to say that the testimony would invade the province of the jury is nonsensical, because just because an opinion encompasses the ultimate issue doesn't mean that it's impermissible for her to testify as an expert and give her opinion in her expert testimony. Additionally, we would argue there's no analytical gap here. The dog was seized by ACS and remained in ACS custody until Dr. Gottbetter's exam. And then as well as the pain in the video at the time of the incident, Dr. Gottbetter, based on her skill, knowledge, education, experience, and training, can testify to her observations of seeing that video in the reaction of the dog, such as vocalizations. So based on all of this, we would ask that you that you find Dr. Gottbetter an expert and permit her to testify to this.
All right, defense, it's your motion. You have final argument.
Yes, Your Honor, and I would just counter specifically as to her testimony that the dog felt pain at the time of the video. That wasn't proved up. There was no cruelty and behavioral assessment. Doesn't allow her to say those specific grounds that are at issue do not allow her to say, hey, on the prior date, this dog felt pain. They didn't prove that up. They didn't ask for training on that specific issue. They didn't ask what she's done or, you know, what part of her practice that consists of. Nor was that her actual finding. She didn't mention that in her finding. That goes outside the scope of her report. We would contend that that goes outside the scope of what she should be able to testify to if she's allowed. And we would ask for her to not be able to testify on those specific grounds.
All right, both parties have stipulated and the court will find that the witness, Dr. Gubbert, is an expert in veterinarian medicine and shelter medicine. The court is going to find, based upon her testimony, that she's an expert in cruelty and behavior assessment. The court is finding that the witness is allowed to testify in the field of veterinary medicine as an expert, in the field of shelter medicine as an expert, in the field of cruelty and behavior assessment to husbandry and animals. Those are the court's findings, and she will be allowed to testify to the assessments that she performed and her conclusions based upon her assessments. All right, is there anything else with regards to that hearing?
Yes, I just need to get clarification, because she specifically stated that she was not able, she did not conclude that specifically that the dog felt pain. So is that gonna be allowed for the?
That will be something that everyone needs to cross-examine the witness on.
So that's why I was asking for clarification.
Yeah.
She said that she could not include that, so
There-
that would be allowed that.
There will be questions will be asked. What I'm telling you all is that the court is finding that she's an expert in veterinarian medicine, that she's an expert in shelter medicine, and that's based upon the party stipulation and based upon the witness's testimony. The court is finding that she's an expert in cruelty and behavior assessment, and that's based upon the witness's testimony. The court is going to find that she's allowed to testify as an expert in regards to those fields. She's allowed to testify as to any assessments that she performed on the animal. She's allowed to testify to her conclusions based upon her assessments that she performed on the animal.
Thank you.
And then parties, of course, are allowed to cross-examine. All right, then the next issue, defense has filed a second motion to quash indictment. State, have you had a chance to review that?
We have your own.
All right, defense, it's your motion. You may proceed.
Yes, Your Honor, and specifically, we have already had a hearing. I just need an actual ruling on this specific issue because it's one or the other. And the last ruling that we got from the court was that our motion to quash was denied. So I wanted to specifically ask for this issue to be addressed because it can only be either a nature of the conduct crime or a nature of the, result of the conduct crime. And based off of how the indictment is pled, if it is a nature of the conduct crime, then recklessly would have to be struck because you cannot recklessly have a nature of the conduct crime. Alternatively, if the court finds that it was a result of the conduct crime, then the state would be required to put in there the result of the crime, which would be bodily injury, I assume, to the dog or some type of result that the animal received. And we did file previously a memorandum in regards to our first motion of quash,
Yes.
which did contain that, Your Honor. And if you need a copy of that, just because it detailed where we are coming from the argument, it is actually in the notes of the pattern jury charge, in which they were trying to figure out how a jury would receive the charge, and they point out that it has to be one or the other, and the courts have ruled on either side of the argument, but we do need a directive, and so whichever one you decide, you would need to know that so we have a unanimous jury charge at the end, which my client would be entitled to. May I approach if you would like
Yes.
to give that? You go, Your Honor.
All right, thank you. Is that the conclusion of your arguments,
It is.
counsel?
And actually, it wasn't the pattern jury charge, it was a comment to the Texas Penal Code. Okay. Well, my Jared Paul, my co-counsel, is informing me that it actually is part of the pattern jury charge comment, so we can provide that to the court.
Okay.
I apologize if I miscited that, but apparently I did.
All right. State response?
Yes, Your Honor. The way the indictment is alleged is specifically tracks the statute itself. The statute calls for this offense to be committed either intentionally, knowingly, or recklessly. So we have tracked the statute, and given that the statute is written that way, I think it is common sense to conclude that it was intentionally put there because this is a result-oriented offense. Now, regarding counsel's argument that it being a result-oriented offense would require us to allege something akin to bodily injury or some sort of physical injury, we disagree because the statute specifically says that this offense is committed when somebody inflicts torture, which the court is aware is defined as any act that inflicts unjustifiable pain or suffering. That is the result. We have alleged that in the indictment. We allege that she repeatedly struck the animal, and the result was the torture the animal experienced, which is pain and suffering. The statute does not require, nor does the, in my understanding, I wasn't obviously present for the first motion to quash, but my understanding of that hearing and the counsel's argument during the hearing is that we should have to prove more than what the statute requires. We do not have to prove any sort of physical injury. I will make note that the definition of bodily injury is pain or any other physical impairment. So I don't think that it really changes what our obligations are. The statute requires that we prove torture. We allege torture. Torture is the result. We think we've complied with the requirements of the law.
All right, defense is your motion. I'll let you have final argument.
So at this time, Your Honor, if the state is arguing that this is a result of the conduct crime and that's what they're going under, you need a ruling from the court as to whether it is a result of the conduct crime or if the court finds it's the nature of the conduct crime.
All right.
Because that's really the issue of conviction.
Just one moment. All right, the court. I'm so sorry, before I make my ruling, State, have you had a chance to review the memorandum that was done by defense?
I personally haven't, Your Honor, but I know my counsel has, my co-counsel has.
All right, so is there any response to the memorandum or no? Because I know that wasn't addressed by the state.
No, Your Honor.
All right. The court has reviewed the defense's memorandum. The court is going to deny the defense's motion to quash. Is there anything else from either side?
Nothing from the state, Your Honor. Your Honor, we're actually just asking for, well, we understand that you denied it. I take it then that, are you finding that under is a nature of, I'm sorry, a result of the crime?
What I'm finding is that your request to quash the indictment is denied on all counts.
So, and I understand that. The problem is that if you are, if we're going to get all the way to the end of the jury trial, it's gonna become an issue of how we instruct the jury. And so, if, in order for you to deny the motion, I can see how you could deny it without doing any other finding. If you said at the nature of, it's a result of the conduct crimes, the state says that it's sufficient. However, if it is a nature of the conduct crime, we will get all the way to the end, and that will be a problem because the law does not allow for recklessly committing nature of the conduct. So that's where I need a ruling on which type of crime the court has found that this is.
May I respond?
Yes.
I think that just based on counsel's statement that recklessly cannot be a part of the nature of the conduct crime, the fact that the statute is written recklessly, it kind of answers her own question. If recklessly can't be a part of the nature of the conduct crime, and that it is in this case, it is in this law, pardon me, then it necessarily follows that it's a result of the offense crime. Result of the conduct crime.
All right, so I want everybody to hear me clearly. The motion to quash is denied.
Yeah.
All right. All right, and so let me look and see when we are set on this case. Do we have a jury trial setting on this case?
Yes, for tomorrow, but I was told that you wanted us to put it on Wednesday instead of tomorrow.
No, you all can come in tomorrow and we'll see where we are. There's another trial that may be in front of you. But is this set for jury trial for tomorrow? Yes, so just make sure you're here tomorrow.